of the month, so we have sobriety court this afternoon, so we have a busy day. Oh gosh, I didn't know we had an AG case. We have a lot going on. We have a number of felony pre-exam conferences, some show causes. We have an attorney general representative that's entered the waiting room. We also are going to need some interpreters. So it's going to be a bit of a bumpy ride. What's your name, ma'am?
Sunny Muscleman. You might have it under Sunny Valzay though.
I got it. Muscleman?
Yes.
M.
Musselman.
Thanks. I'm gonna let this run for just a minute. It does feel like we're just back to work. Vacation time is over. Good morning, sir. Mr. George or Mr. Reed aren't available today. We've got some 3 Rivers and Sturgis pretrials. Mr. George had let us know that last week. So Jeanette, they're gonna just send all the pretrials in here also. So we're gonna have a lot to do before we even get to our felony cases.
Right.
Oh, I see you go. You don't know what you're gonna do. Just go. Mr. Poole's a show cause. All right, I guess. Hello from Canada. Please take your wildfire smoke back. We don't like it. All right, good morning. And I went for my have something removed from my hand. I went to the appointment and they said, you need to have surgery to have this removed. I said, I thought that's why I was here. Apparently it wasn't. I was there for them to tell me I needed surgery to have it removed. So I didn't get it accomplished. So that'll be scheduled. All right, let's bring Miss Brener in. I'm gonna start the record.
Morning.
Good morning. You got your headset on. Looks like you're ready to do some air traffic control. And here we are this morning.
Yeah, my microphone keeps going out, so I have to use this.
It's working. Which case have you got today?
I have Higgins.
Oh, yes. Okay, that's set for Paul Gibson is his lawyer, and sometimes he's not here. I can do a couple things. I can just put you in the waiting room and leave you. It may be a while before I see Mr. Gibson, a half an hour or more, or I can just email you when we're ready. Would you rather I just left you in the waiting room?
Yeah, that's fine, Judge. No
All
problem.
right, I'll catch up with you in a bit. I'll know you're back there. I know you got better things to watch my misdemeanor arraignments, but
Okay, thank you.
all right, thanks. All right, we are ready to begin our arraignments. Jeanette Jackson is here. She's done a good job of shepherding the cases. A lot of people aren't here, but I'm going to get right to it. I'm going to call Sunny Valzay, also Muscleman. Yes, right there. Good morning, Deputy Jamie.
I can sit down, it don't matter.
That would be him, yes.
Go back to work.
All right, are you Sunny Michelle Muscleman?
Yes.
All right, this is file number 251145. Let's talk about that. About 54 cases in the line here. But one of them doesn't appear to be your case, so I'm gonna have to do a separate little search for it. It's under Muscleman. I was looking for Balizé. All right, you got charged. I don't know why it says Balizé, because it's Sonny Michelle Muscleman. It's alleged that in March that you did give false information regarding domestic violence to Chief William Burgoyne of the White Pigeon Police Department, commonly known as false report of a misdemeanor, which is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. The allegation is that you made some sort of allegation of domestic violence that later was either, recanted. How do you plead to that charge?
Not guilty,
All right, would you like me to appoint an attorney for you?
please.
This happens a lot in domestic violence cases. There's an allegation of domestic violence, which is later recanted. So both stories can't be true. Either
I
there
don't know
was an
what I lied
assault-
about. I really don't. I'm really confused on why I'm even here.
All right, well, it
Okay.
says that you told the police that pretrial hearing, Sonny told the court that Andrew did not grab her or shake her. You told Chief Burgoyne that he assaulted you in January, shoved you and shook her during an argument about infidelity by him, and he got arrested. Then you were in court in front of Judge Pattison on March 20th, and they got the transcripts of the court hearing, and you testified in court that he did not grab you or shake you. And you said you were high on methamphetamine and you fell back onto the window. So the prosecutor reviewed those and they watched the video of what you told Chief Burgoyne. And then they looked at the transcript of what you told Judge Pattison. One of them isn't true. So you're left with either a false report of a misdemeanor or perjury, which is often what happens when somebody recants on a domestic violence. So we'll see, but I'll show now that you're pleading not guilty.
Your Honor,
Yes,
I don't know if I heard you correctly, but I thought you said the file number was 1145. It's actually 1146.
1146,
I just
yes.
want to make sure that. you got
All right,
that.
thank you. It may
Okay.
be a vision problem rather than a misstatement problem. We have not guilty, you'll appoint an attorney and set an attorney pretrial for the first Friday of September, which will be 9/5. Are you missing work right now?
Yes, I'm in payroll, so, and then today's my deposit day, so
All
I'm
right, well-
stressing on time.
All right, I'll get you back out there. You go out to the counter and they'll give you the lawyer's name and number. Did
Okay.
you get fingerprinted today?
No, they're gonna do that.
All right. All right, you go out to the counter. They'll do your fingerprints. They'll give you your attorney's name and number. I want you to call the attorney, make an appointment, discuss this with them. As I indicated, there's a body camera video of what you told the officer, and there's a transcript of what you told the judge. So your lawyer will want to get that information
Okay.
and discuss it with you and see how they want to proceed here.
Okay,
All right, you're
all
good to
right,
go.
thank you.
Mr. Poole? No, I'm not sure what's up. There it is. But apparently a lot of people didn't show up. Good morning.
Good morning, sir.
Mr. Poole, the original charge in this file was 2251016 ST was driving suspended. You had an unpaid ticket. You also had some Indiana issues.
Yes, sir.
We set this for July 10th at 8:30. You were gonna pay the old ticket. And then you didn't show up on July 10th. So rather than do a bench warrant, I did a show cause to find out why you didn't show up on July 10th.
Well, I just got my wires crossed. Kind of forgot. Been busy with my mom and dad. They're both not doing the greatest. So,
Well, have you paid your old ticket?
yes, sir.
Unfortunately, the prosecutor isn't here.
And also contacted Indiana with the arrest or the officer that pulled over my twin. And left messages. Been trying to get back with him so I can see what happened there, but I still haven't gotten anything yet. It's been about 2 weeks now.
So you paid your St. Joe County ticket.
Yes, sir.
Still working on the Indiana case.
Yeah, I'm trying.
What's your twin's name? Nathaniel?
Yes.
That's not a very good thing to do to your brother.
No, it's been ongoing since we were about 18, 17.
I had a case once with some girls that I knew. They used to babysit for me. One girl said she was her sister and the mail came for the sister not appearing and she hid the mail. Her sister got arrested, went to jail for a charge that her sister did. Eventually we sorted it out, but that girl was her sister a day in jail.
Yeah, I'm all too familiar with that.
Unfortunately, the city attorney isn't here today. He was here on July 10th. And you were supposed to be here, and I didn't want to go through the rigmarole of arresting you. So are you still at 9th Street?
Yes, sir.
When are you still working on the Indiana thing?
Yeah, I'm gonna call him actually when I get out of work today at 3 o'clock.
Are you missing work right now?
Yeah, I had to leave to come here.
All right, let me get you back to work. I'm gonna reset this. 2 weeks for pretrial with TR. No, this is a county case. All right, we'll reset it, see if you can take care of the Indiana thing. I think the prosecutor didn't give you some consideration. We'll set this for Thursday, August 21st, and I'll be gone that day. Thursday, August 28th. Bring whatever you get from Indiana. All right, you get back to work and let's see if we can get more information. All right, you're good to go. There's no bench warrant, but try to show up on the right day.
Will do.
I didn't want to do a warrant.
Thank you.
All right, you're good to go. We have both felony pre-exams, orders to show cause, and pre-trials and arraignments. So there's a lot of different categories of people. I don't see David Havens, but he's not set till 8:30. Lindsay Miller. That's 8:45, so some of those people aren't late yet. All right, I've got a bunch of arraignments, and I don't know if I got any of the people.
I'll get your sheet.
Kevin Beebe, Betty Bell. Remember Betty Bell?
I don't know, it's something that's familiar,
Yeah, you dealt with her back in the
way
day.
back in the way back. I think.
She was married to my classmate, Franklin Delano Roosevelt, late Jr. Seth Carr. We're not doing too well. Send Michelle out to round everybody up. Troy German. Boy. Jennifer Shoemaker. Hey, it's too much of a nice day or Canadian wildfire smoke or something. Teresa Standish. Wow, all those people are failed to appear. Well, we'll set those aside and we'll have Michelle go out and round them up.
Do you want me to wait around a little bit?
Yes, please,
yeah?
if you would. Let's talk about our pre-trials.
I will be back in a few minutes.
Do you have Trey Hensley in the back?
Yes, sir.
Cheryl Kalu is not back there, is she?
I believe that's the other one.
Arpana?
I'm sorry. I had him talking to.
Okay, Arpana, Cheryl Kalu.
Yes, that's the one I
Why
have.
don't you bring her in?
Yes.
Good morning, Mr. Gibson.
Good morning.
I've got Sarah Brener from the Attorney General's office in the waiting room. Would you like to confer with her?
Yes.
Laura, would you open up the Zoom room so I can have Mr. Gibson confer with the Attorney General regarding Mr. McGann or Mr. Higgins? Mr. Higgins, you owe me some money. We're gonna talk about that too. You got a number of unpaid tickets and other things we'll address. All right. Let's see about our other pre-trials. Good morning. I lost track of you.
Yeah.
Um, I wasn't sure whether you were in custody or not. Judge Pattison was handling your stuff. We've got two old Three River City cases. Filed 24835 OM is a disorderly person charge from May of 2024. File 24952 is an old disorderly person charge from September, or also May of 2024. One was May 11th, one was May 30th. The city attorney, Mr. Tim George, says he would dismiss one charge for a plea to the other. You were in jail for 15 days and then you were out. And I'm not clear, what, are you in jail on a Kalamazoo charge?
No, they just ran my name, and saw that I had open warrants, so they brought me down here on the 27th, but I've been living homeless in Kalamazoo since basically June of last year.
I knew that and I felt bad about it. I do. Did you lose your house?
Yeah, after I got out of jail last year, I mean, I hadn't been able to find a job in town since like January, since I quit American Axle. I don't know what is going on in Three Rivers, but sometimes I was too overqualified and sometimes it's just being an outsider in this town. I couldn't even get a job as a waitress at Mr. B's Dairy Bar. Like, I don't know what was going on.
Well, you got, it shows here 101 days of jail credit. How long have you been in jail here in Centerville?
Since last year, I'm not sure.
When did
3
you,
weeks last year.
when did you most recently get picked up?
It was for the open warrant from last year for skipping out on probation.
All right, and that, okay, and so you've been in jail now since
Just a week and a half since, not this past Saturday.
July 27th.
Yeah,
All right, so that's 4 days in July and 5 days in August. That's 9
No.
days.
July, I didn't do any time. I was in on March 31st till April 16th.
All right, and then, yeah, Judge Pattison gave you 15 days. Then when did you most recently get arrested?
Just now, a week and a half ago.
Okay. So that's 9 days. I'm gonna give you credit for time served. If you plead to one of these, I'll dismiss the other one on motion of the city attorney. Are you willing to do that?
Yes,
All right, well, let's take a look at these. I'm not sure if they're in my queue. Did you ever figure out the estate stuff?
my uncle ended up buying the house on auction for barely anything and has not helped me in any way whatsoever. So he's known, I mean, they reported me missing October last year.
I've been looking for you for, I might have been one of the people that reported you missing way back when you went off the grid. And then I found that you were homeless and in one shelter or another in Kalamazoo.
Yeah,
And I was not,
there's more help for people over there than there is down here.
and there is. Now, my other thought is that you had some inheritance somewhere, either here or India, that was.
India, but with the felony charge, I don't know what I can really do.
All right, well, let's take care of these. I hate to even see you like this.
The inheritance is not much. I actually told my dad's sister to take it,
All right,
so,
so basically you're back at ground zero.
yes.
No family
I'm 40 years
support.
old.
Yes, you're a very intelligent woman. How are you doing with your alcohol issues?
It's been rough. Not that I'm back on and like, I can't survive without it, but just it's stressful being homeless and the situations that arise on a daily. And it's only until recently that I decided that I would stay in Kalamazoo. So for the past year, I've just been in limbo trying to decide if I wanted to stay here or go be closer to family. But I have a lot of loose ends to tie up here. Plus, there's some good colleges. So still haven't figured it out. Western, U of M, or Michigan State. I'm thinking Western.
Okay,
Well, I knew you'd be happy about me going back to school and getting a nice degree. Maybe with Stryker.
well, it's good to have some goals. At 2:45 a.m. on April 11th, Main Street.
I was
You
going to
got
buy
arrested.
cigarettes.
Do you remember even what the deal was?
I was on my way to the gas station to buy cigarettes. It's not my fault that people think it's weird in this town to go buy cigarettes at 2:45 in the morning. I lived in big cities. I didn't have a car. I was walking. There's no sidewalk. I was walking on the
Yes.
street. It's not my fault. The city.
Well,
doesn't
your
have
blood
sidewalks.
alcohol was 0.226, so. And you
I was
taken,
walking.
yes,
Was not in a vehicle. Yeah.
but you got into it with the clerk,
Yeah, she refused to sell me cigarettes. I don't know why.
probably because you were quite drunk.
Yeah, but
All
she
right, so are you willing to
accused me-
plead to that charge and I'll dismiss the other one?
Sure.
All right. Now, let me ask you a couple questions. Other than what I told you here, did anybody promise you anything to get you to plead to this
No,
or threaten you?
no.
Do you understand? And this applies to everybody. By pleading to this charge, you'll be giving up your right to have a trial in front of a judge or jury. There will not be a trial. Do you understand?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Jeanette Jackson is here from the Public Defender's Office, but you could also have had an attorney appointed to represent you. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Understand?
Yes.
So we pled in the April 11th. Or May 11th. Now, I'm gonna let you out of jail. Unless there's something else holding you. Do you have a hold?
No.
Where are you gonna go?
The goal is to try to get back to Kalamazoo. I just don't know how.
Well, you'll just be standing on the steps of the jailhouse?
I'll start walking.
Do you
Maybe
need a
I'll get
bus?
there
Do you
by
need
the
a-
end of the week.
Okay, well, it's Tuesday, gives you till Friday.
Sometimes I get distracted and then need a nap. Like, oh, something's shining over here.
Like an octopus's guard
Or a squirrel.
or a squirrel. I don't even know what to say here, Cheryl.
I don't either. I mean, hopefully I can find a ride into town.
Well, if
And
you
then
need
try
a
to
bus
convince my
pass,
uncle.
you stop here. And I'll give you one.
Yes, please. Because I'd actually been talking to Lauren from Pivotal yesterday, and I was telling her I need, because ISK is in Kalamazoo. And I'd missed a couple of meetings, so they ended up kicking me out of the program, but she said they can't actually do that. So I'm trying to get back in the program so I can get like the help I need, because I like that they are about harm reduction rather than complete abstinence. Like, that's one thing I didn't appreciate about AA, is just they're very cut and dry. That's why I like smart recovery and stuff like
Well,
that.
You know my opinion. You
Yeah.
can't drink at all.
Yeah.
You got a genetic predisposition to alcoholism. You've had a lot of stress and trauma in your life, and it's killing you.
Yeah.
I'm gonna give you 9 days jail, credit 9 days. I'm waiving all the fines, including the mandatory $125 fine.
Thank you.
I am concerned about what you're gonna do when you're standing on the front steps of the jail.
But you said walk over here and you'll give me a ride.
Well, I'll give you a bus pass. I can't give you a ride. I
Right,
could
but
probably
that
get
only
you,
goes as far as Three Rivers.
I could get you a ride to Union City, but you don't want to go that way. All right, as long as there's nothing else holding you, you're gonna get out of jail here this morning.
Thank you very much.
All right, good luck to you. I'll probably see you sometime soon, but I hope not. I hope you get situated and get in a better.
Oh,
Position.
no, you will hear from me because I made a list of all the things I have to do when I get out. You're at the top of the list. I have to send you an email.
All right, I'll be here for another year and a half anyway. All right, you're good to go.
You're fine.
Yeah, so gotta make you new business card for when you retire.
Okay, I need a new business. She had designed some business cards for me one time when she was in sobriety court. I'm not sure who else I got. I lost Mr. Gibson. Let's see if we got Laura hasn't got the Zoom room opened up.
This is Mr. Coleman, Brandon Dodd. Good morning, sir. You're Brandon Dodd?
Yes, ma'am.
All right, hang on just a second. And this is cause number 24, DCCR 2418. Mr. Dodd is charged with murder. And Mr. Burbank, what is the announcement?
I just need, not 2 weeks because I have a trial, but 3 weeks for an announcement. I'm the second attorney on this, and I need to cut it all together and I need to go out and talk to them.
Okay,
And so I can make an announcement.
okay.
State's not opposed to it.
All right, we'll do one more reset. Mr. Burbank's trying to get caught up as quickly as he can. Sounds like he'll be out to see you very soon, so we can get an announcement at that next court date.
Yes, ma'am.
Okay, you can go back with the bailiff. And you have Terry Rose, Mr. Burbank.
I've sent you something.
Good morning. Good morning, you're Terry Rose.
Yes, ma'am.
And Mr. Rose, in cause number 24, DCCR 1369, you're charged with the first degree felony offense of murder. And that's from July 9th of 1999. What that means is if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Burbank that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in the institutional division of the Texas Department of Corrections. You have every right to reject that and go to trial. I just want to make sure you understand any possible consequences, what your options are.
Yes, ma'am.
You understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, I'll get that done. And Mr. Rose, I want to make sure you understand, the lawyers already know, once your case is on the trial docket, I will not accept this plea agreement after today. If you change your mind later, you can plead to something different. The only way it would be much different would be if there was new evidence that either your attorney or the state's attorney did not have at this time. Okay? All right, and have y'all, is there anything you're waiting on as discovery wise?
No, Your Honor, the state's ready for trial.
Okay,
We're ready, Judge. I'd ask maybe it could be specialists set so I can clear my docket out.
we'll get it set in the next day or so and let y'all know that date. If there's any issues, just let me know about that date.
I appreciate
And if you need a protective order or anything like that, to be here, we'll make sure and take care of that and get it done as well. All right, thank you. You can go back with the bailiff. And then you've got Bryce Thomas sentencing. I'm trying to remember which one. Yeah. Let's see. All right, so you're Bryce Thomas, and Mr. Thomas was previously in court, entered pleas of guilty in cause number 24 DCCR 0389 to the third degree felony offense of prohibited weapon. Cause number 24 DCCR 0390, also a third degree felony of possession of a prohibited weapon. Cause number 24 DCCR 0391 pled guilty to the state jail felony offense of theft of a firearm. Cause number 24 DCCR 0392 pled guilty to the lesser offense of indecency with a child by exposure, also a third degree felony. There was no plea agreement. I have received and reviewed the pre-sentence report. Has everyone had an opportunity to review that report?
State has
In addition, there is also the largest packet I've ever received of jail incident reports in a case. Did everyone have an opportunity to review those?
Yes, I took an evening and
35 pages.
I reviewed them one evening. Good.
State reviewed all 35 pages of the
In addition, the state has filed a state sentencing memorandum. Mr. Burbank, did you receive that and were you able to review it? Okay. Anything else, any objections or corrections or additions to the report?
No, sir.
All right, Mr. Burbank, you may proceed.
Your Honor, this is a very young kid that in a very short period of time jumped or stepped off the cliff and got himself in a lot of trouble. I will represent to the court when I was encased by the family. One of my issues was the recovery of the weapons because they were law enforcement weapons. I will represent to the court that almost immediately, mysteriously, weapons ended up in my office in the front hallway and were returned to insurance. And I'd like the court to take notice that those weapons are off the street and back into the department.
Can you speak up a little bit, please?
Oh, back into the department. We go open because I do not have a recommendation. You can place him on probation for a period of 10 years and see what he does. These are third degree felonies that you can do. At the very end, state jail, judge, I believe, the theft of the firearm. You could put him in a state jail for a period of time and put him on probation for the other one. I would ask that if you are going to send him to the penitentiary, that maybe in reference to the sexual offense, that you do place him on probation, so that you can have some accountability for him once he got out for a period of time. That would give the court maybe whether or not he's learned his lesson. Now, as you peruse through the 35 pages of incident reports, and I'm not trying to be funny, because I've talked at length with Mr. Thomas about those. And he'd like to address the court on those. It is what it is, and that's not behavior of whether or not he would be able to follow the court's orders if he can't follow what's going on in jail for a period of time in reference to probation. I would ask that the court would ask Mr. Thomas.
Yeah, go ahead. You have something to say?
What do I have to say? I could just say it's just young, dumb, you know, just being in jail at a young age and not really knowing. But I got write-ups.
Yeah, but once you get several write-ups, I mean, the whole point of growing up is to learn from your mistakes.
Yes, ma'am.
So if you keep getting write-ups, then you can't just say I'm young and dumb. So I keep getting write-ups. I don't disagree that you're young and dumb, but this is ridiculous. Like, I mean, I know our jail cannot wait for you to get out. Cannot wait. Mr. Coleman?
Yes, Your Honor, I'll be brief since I put everything, I made the state's position clear and I sent it to the memorandum. I'd like to briefly shift the focus from the write-ups to the underlying facts in the state's report,
Yeah.
which I believe are.
Stealing out of cop cars.
Stealing from patrol vehicles, at least 2 patrol units, Your Honor. Detective Matt Dixon is here if you want to hear more details of the detective. But Your Honor, I think the audacity, the boldness to steal these weapons from a police car goes to show what exactly the nature of this defendant is and what we're dealing with here. And even more than that, Judge, it appears from the underlying facts that the defendant may be implicated in a series of other car burglaries. We've got a Glock switch that converted one of those weapons into a fully automatic weapon. He was conspiring with another juvenile, a 16-year-old, to steal the weapons, which a photograph is attached to my sentencing memorandum if you've seen it. This was nothing less than an arsenal that these kids amassed, Judge. I shudder to think what could have become of these weapons if they would end up in the hands of other criminals, if they could have been used to use law enforcement. Your Honor, long gone are the days where there's a low caliber Saturday night special that these kids use, you know, in some type of crime. They are loaded for bear with fully automatic weapons. I'd ask the court to make an example out of this defendant. He benefits from not having a criminal history to speak of, but Your Honor, this is beyond the pale. I'd ask you to send him, do 2 things, a split sentence in this case. Sentence him to prison for what he's done, and then following that, a consecutive probation period so that we can continue to monitor him and supervise him after he's released from prison. Thank you, Your Honor.
So I wanted to make sure, Mr. Coleman, I've done this type of sentencing that you're asking for on some different cases. I think the probation period, if I sentence him to probation today, I don't know that I can make that consecutive. So I think
I believe you can, Judge, and if you need to recess this proceeding, I can get you case law in pretty short order. I think
because when would it start?
it will start after he finishes his period of incarceration.
Okay. So whatever I give him, if I do prison, and then I say it's consecutive with a probation, and does it matter if it's a straight or a,
I don't believe so either, Judge. But again, I'm happy to get you some case.
No, I appreciate the idea. Again, we've done it sometimes. I mean, what are y'all doing? What are you doing with all these?
In Texas, a judge
Not shooting people.
Sir?
Not shooting people.
Not shooting people yet. What are you shooting? Why would you have these? What are you getting these to shoot at? Just to be tough and say you have guns?
No.
That's all that's happening with these guns on the street is y'all are shooting at each other, at other people, at houses, at cars, at whatever. There's no reason to have these kind of guns. These aren't hunting guns, right? You're not going to shoot a deer. Do you hunt?
I do.
Do you?
I have before, but
Have you?
yes,
Which one of these is your hunting gun?
none of those.
You thought you were pretty bad breaking into a cop's car, didn't you? That is some nerve. I mean, seriously, you're the second person I've had in 11 years that has had the nerve to do that. Here's what I'm going to do, because I agree with, but Mr. Coleman, I would like, at least in the indecency case, to get treatment and probation on that case so that we know you're not going to go make that type of bad decision again. But I'm not giving you probation on everything. You're going to you want to change your life and do better and not be young and dumb. You're going to have some time to figure that out. So in cause number 24, DCCR 0389, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Mr. Coleman actually asked me to sentence you to 5 years. I don't think that's enough. I'm going to sentence you in that case to 7 years in the institutional division of the Texas Department of Corrections. You'll receive credit on that sentence for any time you've been in custody. And part of the reason I made it lengthier is because you have been in custody so long, and a 5-year sentence really isn't going to amount to much. Cause number 24, DCCR 0390, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 0391, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of a firearm. Sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Then in cause number 24, DCCR 0392, find sufficient evidence to find you guilty. However, in that case, I'm going to defer all proceedings, place you on probation. No, that's the third. I'm going to find you guilty of that offense, sentence you to a term of 10 years in the institutional division, but I'm going to suspend that and place you on probation for 10 years.
Can I address the court on that?
Mm-hmm.
With the deferred, though, with the registration, it would, if he did comply after he got out, that he may have a chance instead of a conviction.
He's already got 3 convictions.
Well,
The
I
fourth.
understand that, but a sexual kind of.
May I respond, Judge? That is a reduced charge.
I agree.
I want to ask.
Can I give a straight on indecency though? Hold on. I think it has to be deferred. Hold on. Yeah, it has to be deferred. Okay, so I'm going to go back in that cause number, which ends in 0392. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and I'm going to place you on probation for 10 years. That will run consecutively to the other cases. So that probation does not start until you get out of prison. Then if you violate that probation, you could be sentenced up to 10 years in that case. So you're going to be under supervision or in custody for a very long time. So if you really want to change your ways, you're going to have every opportunity to do that. If you don't, you're going to end up, number one, you're probably not going to make parole if you keep acting like you've been acting here. If you get to prison and you act like this, you're not going to make your parole. You're going to do that whole 7 years. That's going to be up to you. The sooner you get out and act right, the sooner you can start this other probation and get off of it, grow up, and maybe change your life. That's going to be up to you. On that deferred, I am going to order a $500 fine that you follow all of the conditions of probation. That's going to include sex offender treatment, going to whatever classes are necessary, staying clean, not getting in any trouble, all of those kinds of things. Do you understand? Mr. Coleman?
Your Honor, is there a deadly weapon finding option with these weapons?
I don't think so.
Okay. Okay.
Unless you can, I don't think that's.
We didn't allege it.
Well, and they're not, possession of a prohibited in the 3G. So I don't think we can.
Okay.
Yeah. All right. So all of these are actually wrong because y'all marked off plea bargain and there wasn't a plea bargain. So I'm going to hand you the trial court certification in all of your cases. This shows that these were not a plea agreement.
It was a plea agreement, Judge, because there's a, no.
Oh, because of-
No, there was an unauthorized use that we agreed would be dismissed.
And also the lesser offense in that. So there was consideration taken. So this was an agreement, at least for those reductions. Okay. So you have waived your right to appeal. In these cases, I'm going to hand you those certifications. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. You can go back with the bailiff.
I thought you,
Yeah.
you have Mr. Jenkins that you're gonna.
I've received the pre-sentence order and Nerberto Frelow.
We're not gonna ask for that right now.
Okay. Good morning, you're Nerberto Frelow?
Good morning, Your Honor.
And Mr. Frelow is charged in cause number 25 DCCR 0366 with the first degree felony offense of murder. And Mr. Galmore, what is the announcement?
Judge, we have a pending writ on file for bond, or we would ask the court to set this for hearing next week on whatever day is available for the court.
Okay.
I received it. It was filed
It was last
yesterday,
night,
Judge. And that's fine with me.
So we had a bond, already had a hearing.
I'll let the court know. I think it's probably going to need to be heard. There's an issue that Mr. Galmore, his investigator brought to us that I have 3 investigators checking out as we speak.
Okay.
And that will guide our.
Okay.
Forward, Your Honor.
We'll set it for next Tuesday for a hearing on that writ.
Okay,
We'll see you Tuesday.
Thank you, Your Honor.
Is Mr. Stephen Harris here? Mr. Harris, are you ready on Camden Jackson sentencing? Good morning. Yes, ma'am, thank you. All right, are you Camden Jackson?
Yes, ma'am.
And Mr. Jackson, you were previously in court, entered a plea of guilty to the second-degree felony offense of engaging in organized criminal activity. I've received the pre-sentence report as well as incident reports from the Jefferson County Jail. Has everyone had an opportunity to review all of that?
Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor.
Judge, only I'm sure the court would like Mr. Jackson to take a little bit more responsibility than he did in his version. And I would also assume that his next comments are going to be the talking to that everybody else in the jail is doing. Right?
Mr. Jackson, I've got 16 pages of jail incident reports. Each page holds 2 to 4. Do the math on that, and that's a lot of you being exceptionally disrespectful to the officers that are there. And so what I'm wondering is why you think, I mean, since you entered your plea in this case, you were caught with a shank, 2 different types of shanks, and you've been fighting, huh? You can speak where I can understand you first. Speak up. What do you want to say?
I was talking to the guard, I was talking to the lieutenant. I was trying to talk to him and get that thrown out. They ain't find it on me.
No, they found it in your bed.
Oh, it wasn't.
Okay. What about the other 16 pages? What about telling the officers, I don't have to do shit? What about telling the officers, I don't give a F about none of that? What about that? Is that you? Over and over and over? If you don't give a shit, then why should we? Do you understand what I'm saying? You want to spend your life in prison? Because that's what you're asking for. It's no behavior for me to go, oh, let's just put him on probation. It'll be great. He's going to follow the rules. You can't even follow the rules when you're locked up. What makes me think you're going to follow them when you're out? I mean, the agreement that y'all have reached based on what I understand is very little criminal history, mostly because you're young and you haven't had time to do a whole lot. What is the status of the Hardin County cases? Do we know?
Yes, Your Honor. They're waiting for us to resolve these cases, and then they'll be next in line.
Okay.
When we come to court, after we leave, I always inform them what we're doing, so they're aware.
Okay.
Judge, that kind of goes to the notion of, obviously, we were going to request if the court is in agreement with the following plea, ISF, that he cannot do with those pending. So our understanding and our agreement was for ISF, with the understanding that he would dispose of those cases very timely so that he can then go to ISF if that's what this court orders.
Yes, Your Honor.
Okay. So here's what I'm going to do, Mr. Jackson, and the rest is going to be up to you, okay? I'm going to follow the agreement that you made with the district attorney. I'm going to find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to defer all proceedings for a period of 7 years. You will be ordered to pay a $500 fine. You will be ordered to enter and successfully complete the cognitive track of the ISF program. That is a whole program, especially for you young people, to hopefully help you to make better decisions. But here's the thing about ISF. You're going to go to Hardin County from here, take care of those cases. And when you do get to ISF, 1 incident report is a violation of your probation. 0 tolerance. So you're going to have to prove to me while you're waiting in jail. In addition, while you're waiting in jail to go to Hardin County, if I find out you misbehave in Hardin County, any of those things are going to be violations of your probation. Do you understand? A condition of your probation is going to be that you follow the rules in our jail, in Hardin County Jail, and in ISF, whatever those rules are. It's not going to be cussing at and calling names to the correctional officers who are just there doing their job. It's not going to be fighting. It's not going to be hiding things in your whatever. You understand? Because you may never see the light of day. You're going to be right back in here on a motion to revoke your probation. And because this is a 2nd-degree felony, if you are back in here, the range of punishment, if I find that you violated your probation, is minimum 2 up to 20 years in prison. You understand that? Okay. If you take advantage of this opportunity and change the way you're acting, and are you successful on this probation, this is your chance of a lifetime today, because you do not have a conviction on your record. You're not a convicted felon. And at the end of the probation period, if you're successful, the case gets dismissed. You'll never be a convicted felon. The other side, again, though, 1 hiccup. You're on 0 tolerance from the beginning on this. You're back in here with the motion to revoke and going to prison. Do you understand? A condition of your probation also, if it's not in here, is going to be that you are not allowed to be in the possession of or around any firearm So if there are firearms in your house where you're living that aren't yours, they have to be locked up, or you are not allowed to have them. You're not allowed to have a firearm, period. Do you understand? Okay.
And Your Honor, just for the record, we do believe that he'll be able to make this probation and won't be back here. His family is here. They've always been here, so they're
Good.
ready to support him with whatever he needs to make sure that he makes it over the hump.
I hope so. I'm glad that they're here. And here's the thing, you probably don't like their rules either. Guessing from how you're acting, I don't think you like anybody telling you what to do. But at this point in your life, until you get off this probation, there's going to be a bunch of people telling you what to do. And you're just going to have to take that because you're the one who engaged in this behavior, right? So grow up, take responsibility, and change it. It's all up to you to do that. Okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. Thank y'all for being here.
Thank you, Your Honor.
Thank you, sir. Ms. Holmes, you have is Ms. Holmes here? Kevin Harmon, that's a sentencing.
Kevin Harmon.
Bye. Good morning. All right. Finally. Look at this one. Get it, just a check mark.
I'm about fired up to argue this guy's report. He's only got like 2 pages.
No, I've got a good check mark on this one.
After 35.
I mean, seriously. All right, sir, you're Kevin Harmon. And Mr. Harmon was previously in court in cause number 24, DCCR 1612, entered a plea of guilty to the second-degree felony offense of assault on a peace officer. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections?
None from the defense, just that he takes responsibility for his actions.
Okay.
I didn't have anything to add, Your Honor.
All right, so Mr. Harmon, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because this felony conviction will not be on your record as a conviction. And at the end of the probation period, if you're successful, the case gets dismissed. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would become a convicted felon, and I could sentence you anywhere in the range of punishment, which is between 2 years up to 20 years in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. And you can go back with the bailiff. Probation will give you some information on what to do when you get out.
Thank you, Your Honor.
Thank you.
Judge, I reset one of Marvin Lewis's and I'm resetting Lori Brazos.
Okay.
Marvin Lewis at the Charles,
Bryce and Charles.
yes.
Okay.
It's reset.
Okay.
And Lori Brazos, Dr. Wade. Thank you.
Thank you. Mr. Radford?
Yes, ma'am.
You've got Michelle Cormier.
Yes, ma'am. She's on the other side.
There, she's next door. Okay, just let me know when she's here and I'll take it up as soon as she gets over here. What about Corey Flemings?
He's a plea bargain rejection. He's here.
Okay, let's take care of that one while they're getting her.
Mr. Martin is a plea to misdemeanor Thompson.
Thank you.
I've got a discovery issue on Mrs. Cormier.
Okay.
Mr. Coleman, I have that Corey Flemings is 8. Is that correct?
It's at 8 today, but I think he can become, he can be enhanced a little bit.
I see one enhancement. Is there more that aren't in the?
There is an out of state judgment from Louisiana that's under the penal code would be 30 degrees felony.
No, I need to admonish him of that because I was not aware of the out-of-state prior.
Y'all want to visit for a minute?
Yeah.
Yeah, y'all take a look at that, and that way, once we do it, I'll be there. I'll hold it.
Yeah, we need
Mr. Flemings needs to just
to visit.
go back for a minute.
Ms. Cormier's here, Judge. and Mr. Cole.
Okay.
Yeah, just go back because I gotta talk to you. I was not aware of
I'm trying to pull your motion up. I can bring my whole file.
Michelle Cormier?
It's a discovery measure.
Give me just a second. All right, ma'am, are you Michelle Cormier? And in cause number 25, DCCR 0153, Ms. Cormier is charged with a first-degree felony offense of murder. And what is the announcement?
Judge, this event occurred in the Jefferson County Jail. I asked Mr. Coleman if there were any surveillance videos that were relevant to the incident, and he told me I needed to see them.
Actually, there was a two-part request on part of Mr. Rapper. He also asked for the criminal history of, was it the deceased?
Yeah, the deceased.
I'll make that available.
Okay, the videos as well. I mean, if there's,
They're in the custody of the state.
yeah, if there's
I
evidence,
was trying to pull up his request because I think it was more global than that, Judge. I think you asked for videos like to and from the jail, which
Any relevant surveillance videos is what I want.
okay, all right. I think that's something that the state would need to get with the jail and find out if there is any and provide that in discovery. If it's inculpatory or exculpatory, I think would be considered just discovery.
Forgive me for being unprepared on this.
No, that's
I'm trying to
okay.
pull up the actual motion because I think there was more of a.
Well, y'all visit, work out what you need, and if it's something that they won't release to you, then we can get a subpoena or an order done. If there's something that you feel like is overly broad, y'all talk about it, see if you can work it out. If not, we'll have a hearing on it. But I'll just reset it for a normal announcement to give y'all time to work on all that.
Okay.
Okay, you can go back with the bailiff.
I will go visit with Mr.
What about Traylon Martin?
He's a plea to a misdemeanor time, sir. If you want to do an announcement.
Let's get Traylon Martin.
Traylon Martin.
My mouse, my pointer's all jumpy for some reason.
Corey Flemings and a Jacorian.
Oh, really?
How was your Where'd you go?
Oh, any idea why this would be all jumping around? I can't. Maybe in a second. All right, you're Traylon Martin,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
Yes, ma'am.
Judge, with the court's permission, based on the facts of this case, some of the circumstances, we have elected to proceed on a lesser included evading just from, based on where his location was. He was on his own front porch.
Was it I put resisting, but I don't have a problem with going.
Either is fine. The fact.
So it's, which one? Y'all pick.
Resisting is fine.
I think resisting
So-
is probably a lesser.
Lesser of resisting, is that a class A or B?
Hey.
You've got the third degree checked off on the
Well, that was the
admonishments.
original,
Yeah, we've got to admonish him to what he's pleading to.
right,
Let's
that was
see.
the original admonishment.
Yeah. Class A. What's the max fine on a misdemeanor?
4,000.
Thank you. All right, Mr. Martin, in cause number, will he waive the formal reading of the indictment?
Yes, ma'am, he will.
Mr. Martin, in cause number 25, DCCR 0270, the state has elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest. And that is from January 29th of 2025. And how do you plead to that charge?
Let's get it out the way and go home.
Okay, you just. say
What is your plea?
guilty or not.
Oh, for the charge
Of resisting arrest?
I'm just gonna go with,
No, you don't get to just go with anything. Either you did it or you didn't do it. So are you guilty of resisting arrest or are you not guilty of resisting
Now,
arrest?
one moment.
I'm gonna go with yes.
Okay.
You don't get to just go with guilty, okay? You need to say, because here's the thing, you just got sworn in over there and you're under oath to tell the truth. And so I'm asking you some questions while you're under oath. So taking a deal just to get something over with isn't what we do here.
Yes, ma'am.
You either did it or you didn't do it. Do you understand? So to the charge of the lesser included offense of resisting arrest from January 29th of 2025, how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Martin is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser included offense of a Class A misdemeanor resisting arrest. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence. Have y'all checked that he has 180?
He's been in jail since January.
So you'll get credit on that sentence for any time that you've been in custody,
Yes.
that the law gives you the right to receive.
And I request some backup time. Okay.
You get credit for any time you've been in custody.
Oh.
All right, so if you've been in custody since January, you'll get all of that time credit. Do you understand? I'm going to hand you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
All right, thank you.
Yes, sir.
I'll go visit with Mr. Fleming.
Okay. You can't tell. I don't know where this, no, I think it's a little better. I don't know what's happening. My computer keeps popping up. Oh. Is Mr. Young here? Okay. Mr. Young? Oh, wait, is he in the back? Okay, I'll call him back in a second with Mr. Vasquez. We've got Andre Williams.
Yeah, sure. Good morning.
Good morning. How are you?
Good, how about yourself?
All right.
I have 8 dead victims on today.
There's a lot. We have a lot of.
No, I have 6. We have 8 total.
8 total.
So I have 3 murders and 3 manslaughter.
Yeah.
Okay, I'm actually about to leave one.
Wow. All right, sir, are you Andre Williams?
Yes, ma'am.
And in cause number 24, DCCR 1539, Mr. Williams is charged with tampering or fabricating physical evidence. And in cause number 24, DCCR 2286, Mr. Williams is charged with a first-degree felony offense of murder. And we'll get this pulled up because we had Mr. Williams examined for competency.
Yeah, sure.
And we've received that report from Dr. Capon. Dated May 29th of 2025. The finding in that report by Dr. Capon is that Mr. Williams is currently competent to stand trial. Is there any other evidence with regard to competency?
No, ma'am.
No, Your Honor.
Then at this time, I am going to find that Mr. Williams is competent to stand trial. Mr. Vasquez, what is the announcement?
Judge, I'm asking for 30 days. The reason being, there are some Social Security Administration records that I don't have, that I have not subpoenaed, I've become aware of lately. A family member thinks they could be useful. I know the court sets trials out for probably 30 or 45 days anyway, but I'm just nervous about getting on the trial docket today without those records. I'd like to have them.
Okay, well, I'll give you one reset for that. Any issues?
No, Your Honor, we did do a rejection today before you're off, which I think we've done that before.
Okay, so I'll just do a normal reset, which is about 30 days. Make sure you get that subpoena done quickly, and that way you'll have what you need, and we'll get an announcement at the next court date.
Thank you.
Okay, you can go back with the bailiff.
Thank you, Judge.
Yes, sir.
Mr. Kimler, you have Melissa Taylor to sentencing. Happy vacation.
How's your vacation?
If there are people in jail.
I appreciate that.
He's here, I just saw him.
Melissa Taylor. Good morning, you're Melissa Taylor?
Yes, ma'am.
And Ms. Taylor was previously in court, entered a plea of guilty in cause number 24 DCCR 2177 to the second degree felony offense of assault on a peace officer, and in cause number 24 DCCR 2311 to the state jail felony offense of credit or debit card abuse. The agreement was a cap of 5 years in the assault and a cap of 12 months. And the debit or credit card abuse. I've received the pre-sentence report. Have you all had an opportunity to review that report?
We have. Yes, Your Honor, we have.
Are there any additions or corrections?
Not from the state judge.
All right, Mr. Kimler, you may proceed.
Your Honor, I'm anticipating Mr. Nichols' argument. I would first want to address the incident reports from the jail that have been attached to the PSI report, and then also reference in the PSI report. Of course, it's difficult for me to assess the credibility of those without the opportunity to confront and cross-examine the witnesses, but taking them at their face value in here, of course, indicates a pattern of behavior that Ms. Taylor exhibited in jail that shows that she was not compliant. I would observe, though, that there is no write-up subsequent to July of 2024. I think she went back into custody in April of 2025 and has had no incident reports since then. I've been speaking with Ms. Taylor and trying to understand what was going on in the jail. I think that she was struggling with mental health issues while she was in jail during this stay when she accumulated these write-ups. She indicated that she was, after an assessment, psychological assessment, she was on around 5 different medications, including
Seroquel, trazodone, and lithium.
But a veritable cocktail of psych meds during.
Judge, not to derail Mr. Kimler, I'm kind of in agreement after reviewing the PSI that what she needs is treatment and mental health.
Okay.
So
Well,
that may make the course.
I'll cut that short there.
Okay.
We'll defer to, but she wanted to address the court, and I'll defer.
Go ahead, ma'am.
Yes, ma'am, I just wanted to piggyback off that. Those were during a state of psychosis with the meds that I was on. That this last 4 months that I've spent in jail, I've put myself through basically a mental rewiring of my brain chemistry through the literature that I'm reading. And I've had a lot of success with my behavior. My son has been reintegrated into my life again without his father. The family that has him, we're in contact every day, which has been tremendous for my mental health and is a key aspect as a woman yourself, but I'm sure mom. He was my identity for 12 years. And when he was taken, I lost my identity. And that was a huge part of this last year. But I don't want to look at this last year as being a victim. I want to be victorious over this and really turn this mess into a message. And I just hope that I get to be integrated back into society.
She is, what is the bed you're on now that's helping?
I'm on, it's oxycarbazine, just one medication now is all they have me on. And so it's been, yeah, it's just a mood stabilizer.
All right, well, here's what I'm inclined to do. Obviously, you were having the mental health issues and self-medicating.
Yes, absolutely.
With just about everything. It's okay. And so if I'm going to feel comfortable giving you a probation, it's going to be with some treatment, obviously. So I'm going to find in cause number 242177, find that you entered your plea freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings in that case for a period of 10 years. You're ordered to pay a $500 fine, follow all of the rules and conditions of probation, and I'm going to go over some of those special conditions in just a minute. In cause number 242311, also find sufficient evidence to find you guilty. However, I'm going to defer all proceedings in that case, place you on probation for 5 years. You're ordered to pay a $500 fine in that case as well and follow all of the rules and conditions of probation. One of those conditions is that you enter and successfully complete the Special Needs SafeP program. So that's a kind of a dual program where you're going to get help for any type of drug issues that you have in addition to mental health care. Once you get out, you'll be on probation and you'll be able to hopefully have the follow-up treatment, follow all of those rules, and be on the way to doing exactly what you're saying.
If I might, she has pending cases in Fort Bend County. She'd have to resolve those before she goes.
Do they have a hold on her?
Yes.
All right. Well, then, so what'll happen is you'll go to Fort Bend County, resolve those, and then you'll have to go to SafeP after that. Okay. So the sooner you get over there, resolve that, the sooner you can get to Special Needs SafeP and get back out and on track to do again what you say you want to do. Okay.
There's no way that I could, that's it. Like
yes, ma'am. It's the only way. It's the only way with this cap and with the history and with what's been going on that I feel comfortable. It's not meant to necessarily be a punishment. It is treatment up front so you can be successful.
You said it was 90 days.
6 months.
This is more, yeah, I think it's closer to 180.
with
Okay.
aftercare.
And then the aftercare is out, but you'll go to halfway house. You'll go, there's some step down after you get out where you'll be out doing different things, but following some very strict rules for aftercare. Okay. So I'm going to hand you the trial court certification in each of your cases that shows that these were agreements that I followed. And so you've waived your right to appeal. Good luck to you, ma'am.
Thank you, Your Honor.
Peyton Woodruff, Mr. Kimler, is the sentencing.
You discuss this in dialogue?
I don't know my biology. It's probably in my Bible. I haven't
Not have cases yet, and say that.
Not the real case. I have to put something on the record.
Good morning, ma'am. Are you Peyton Woodruff?
Yes, ma'am.
And Ms. Woodruff was previously in court, entered a plea of guilty in cause number 24, DCCR 1710 to the state jail felony offense of burglary of a building, and in cause number 25, DCCR 0426 to the second degree felony offense of robbery. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
State has to.
Any additions or corrections to that report?
The only correction I observed, Your Honor, was actually, I think it's a typo where they talk about moral, the MRT program. And they reference it as recognition. I think it's recognition.
Okay.
Misspelled. It's not,
Yeah.
that's, I think that's the problem.
Okay.
Nothing from the state.
And Mr. Coleman has filed a sentencing memorandum as well as a request to state's motion to accumulate any sentences. Is that correct? Mr.
That's correct, Judge. I'm inclined to withdraw that motion to you.
Thank you. All right. All right, Mr. Kimler, you may proceed.
Basically, Your Honor, I would defer to the pre-sentence report. It seems to contain all the information necessary for the court. In my mind, I'm not saying the court is bound to give a probation, but certainly the pre-sentence report certainly would tend, in my reading, to indicate that that would be the appropriate sentence. I think paramount in that analysis is the defendant's recognition of her failures and acceptance of responsibility, which is clear from her rather articulate.
You can speak up, please.
It's just clear from her rather articulate expression of that in the pre-sentence report, where she accepts responsibility and seems to have enough insight and self-awareness to realize that she needs to make changes in her life to be successful. She has been successful in the past in light of criminal history. You can see from the report. And again, we would just defer to what appears to be the recommendation, the implied recommendation, I suppose, of the pre-sentence report to put her on probation.
Mr. Coleman?
Your Honor, just state, simply made his position clear in his sentencing memorandum. A series of events, notwithstanding her last criminal history, but that criminal episode that she engaged in, whereby she received 4 felony offenses, a burglary, robbery, 2 possessions of a controlled substance, I think justifies a minimum jail sentence of 2 years on the robbery, judge, and a 24-month sentence on the state jail burglary and life concurrent.
The only thing I would observe, Your Honor, obviously that's a minimum sentence, and that would kind of be the easy way out. But the problem with that is it gives her felony convictions.
No, I'm not inclined. I mean, while I agree with Mr. Coleman that this was kind of a lot of things that happened very quickly, the lack of criminal history shows, in my opinion, that things were going on with regard to substance abuse and mental health. And I think this is a case that would be, I don't see any reason that there would not be a probation given that opportunity at least. So Ms. Woodruff, in cause number 24, DCCR 1710, I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation. In that case, that's the burglar of a building for 5 years. You will be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'll talk about those in just a minute. In cause number 25, DCCR 0426, also find sufficient evidence to find you guilty, but I'm going to defer all proceedings, place you on probation for 10 years in that case. You're ordered to pay a $500 fine and you're ordered to follow all of the rules and conditions of probation. You will, when you're on probation, they will do a substance abuse assessment, and then they will recommend whatever treatment. And whatever that treatment is that they recommend, whether it's inpatient, outpatient, if they think you need something, then you will be ordered to do it. Do you understand?
Yes.
Also, you'll get a mental health assessment to see if there's anything that you need there to help you be successful. You will be ordered to follow all of those rules as well. You are to have no contact with the victims of the offenses. That's a Toni Morrison and Logan Kotlerich. Also, what is the relationship with John Toops?
He is my ex-boyfriend.
He's going to remain your ex-boyfriend. So you will have no contact or communication with him either. Do you understand? And so if you do everything that you're supposed to on these probations, this is an excellent opportunity. You're fairly young. You don't have criminal history. Obviously, you were going through, like I said, substance abuse issues and mental health issues, and you went all in pretty quickly. This is your opportunity to not be a convicted felon and to be able to serve any sentence while you're out on probation. The downside to that, though, is if you violate any condition of probation at all, you can be brought back into court. You could be found guilty, so you would be a convicted felon. And in the robbery case, you could go to prison for up to 20 years, and in the burglary, up to 2 years. Do you understand?
Yes.
I'm going to hand you, in each of these cases, the trial court certifications that shows that these were not agreements. And so you do have some rights to appeal. You can talk to Mr. Kimber about that. Yes, sir.
Yeah, there's the matter of a pending drug case.
Yeah.
She was arrested in July 21st, 2024, for somehow our office has obtained a lab report from that case, but not the actual case referral. About 2 weeks ago, I put in a call to the sheriff's department, the narcotics department there at the sheriff's department judge, and apparently returning phone calls is an outdated concept because I've not used the phone call back.
Welcome to my world.
Yeah, I was asked to leave a message for Donna in narcotics, and she has today not returned my phone call. So the Jefferson County, BPD, not Sheriff's Department. So the BPD case number is 2024-14337, and this disposition of these cases is intended to dispose of that case as well.
So if it does come into the office, you're going to not in time. So that's the 2024 one. What about the 2025 case?
Well,
The PSI shows two. The PSI shows that July one from 2024, but it also shows a March of 2025.
I'm not aware, that would just, is there a case number?
No, it's just listed.
I don't have any heartburn over declining that one as well, Judge. I don't have a case number to put on record or anything like that.
Okay, if you'll just kind of watch for it, then we'll hopefully catch it. Y'all can catch it before it.
If the court wants to construe that as an agreement, then we would waive our right to an appeal. If that wants to, if we have an agreement that they're not going to be.
Well, that's what we would need to change all the paperwork. That's done. I can't imagine that getting a probation, there's going to be an appeal issue anyway. So, all right, good luck to you, ma'am. You can go back with the bailiff.
Thank you, y'all.
Yes, ma'am. Mr. LeBlanc, you have Marcus Austin. Okay. Good morning. Good morning, sir. Are you Marcus Austin? And in cause number 24, DCCR 1942, Mr. Austin's case is set for trial to begin with jury selection next Monday. And what is the announcement?
I believe we've come here before. I think it's been announced already. I believe, I'm speaking to the prosecutor.
I can't hear you.
There may be another case that's, I don't especially set, but I'm ready.
Okay. Are you ready,
State's
Mr.
ready,
Nichols?
Judge.
Okay. Obviously, I do have another one that we intend to go forward, but things like that change all the time. So I want to make sure Mr. Austin previously, oops, hold on, rejected an offer in February. It was a 35-year sentence. This is an aggravated assault, family violence with a weapon. 35 years was the offer. Nothing's changed with
No,
the
you're
part
right.
of
That
that.
offer will not change.
All right, and you want to go forward with your trial? We're not here to negotiate. Mr. LeBlanc, I'm sure, has been negotiating with the district attorney.
And Mr. Bond's got with me several times asking if there was any wiggle room, and I've told him strongly no on every occasion.
Okay, so there's your answer. It's 35 years or go to trial. So do you want to reject that and go to trial and let a jury decide? Or do you want to take the 35? What? All right, I'll hold it while y'all take care of the paperwork. What about Lenny Leday? Sometimes it helps when they hear it out loud from everybody that this is it. Oh, well, I don't know. That sounds very reasonable. Oh. Pick Burger King. You get it your way. Or not. Good morning. Are you Lenny Leday?
Yes.
And Mr. Leday is charged in cause number 23, DCCR 0783 with the offense of sexual assault. And what is the announcement?
Judge, I need a little more time. I mean, he's made an offer. I think the court made notice. The prior attorney, I'm speaking with Mr. Radford. He's got some things in his file that I need to look at.
Okay.
And I just found that out. So I need to get with him. I mean, you can set it on, I believe this is an older case, even though I'm new on it.
It is, and it's gone through some attorneys. And so I'm going to give you 30 days. You need to take all that time, get completely caught up so we can get an announcement, visit with Mr. Radford, Mr. Hoffbauer, and then I want an announcement at the next court date.
And I believe the announcement's going to be trial. I mean, it's
Sure.
trial. So
I just want to make sure you've looked at everything and that you go over it with Mr. Leday, even though other attorneys have. Y'all go over everything again, talk about consequences, options, and then we will get an announcement. And if it's a trial announcement at the next court date, we'll get it on the quickest trial docket. Okay? You can go back with the bailiff. Okay. Mr. Young? Good morning. Good morning, sir. On Salvador Gomez?
Salvador,
How are you, sir?
I'm well. How are you?
Good, thank you.
The only thing I caught in the motion language is about pictures and video. It's just like I was together.
Good morning, you're Salvador Gomez. And Mr. Gomez has 3 cases, 2 intox manslaughters and a driving while intoxicated set for trial for jury selection next Monday afternoon. And what is the announcement? Is everybody ready?
Yes, Your Honor, state's ready. I know Mr. Young's ready to discuss. And we asked for a special setting and everyone's, as
Right.
far as I know, ready to go.
Okay. Anything, it looks like there was a motion in limine filed recently. Any issues that we need to take up today with regard to that? Or do y'all want to handle it Monday before we get
Probably
started?
Monday. Judge, it's pretty standard. It's about showing graphic video or pictures. The only issue is in this case, there's really, everything's going to be graphic. And I will do my best, as you know, I've done in the past, to cut it down. I don't want to inundate the jury or the audience with gore, but it's a double fatality that ended up fiery crash. So I mean, I don't
I
have.
mean, obviously,
pictures
some will be
graphic.
necessary, but we can go over at the time any limitations that,
We'll be
during
as
that.
reasonable as we can.
I
Okay.
think we just, ask that they articulate the probative value.
Sure.
Because I think there are a lot that probably,
Certainly.
especially given that I don't know who really contested intoxication, causation. And while he hasn't finally made his decision, we still anticipate pleading guilty to the jury.
okay, and just going forward with punishment.
And in that regard, Judge, I have an election for punishment and an application for community supervision. Can I file those with the court, or would you prefer that I file those electronically?
It's so much easier if you do it electronically.
I'll just do it.
Otherwise, they have to do it electronically for you. So.
I'll take care of that one.
Perfect. Thank you. And if you need, on the application, the clerks while you guys are here.
She did it for
She
me
already
last
did it.
time.
Okay, perfect. All right, anything else then?
No, Your Honor, I think everyone is prepared to move forward.
All right, we'll see y'all.
As far as scheduling, Judge, because I know his wife and his kids are frankly all working now. And so I'm assuming if I have him here Thursday morning, does that sound probably when you'll be done?
I think that's reasonable.
One of,
It's always hard to say.
I know it's hard
I
to
would
say.
rather, it's hard to say, I know for all of you guys, I would rather, and I know if they're working, we don't want them to miss too much work. I would rather them be here possibly a day early, just in case. What I don't like to do, if I can avoid it, is have a jury have to leave at 2:00 some afternoon because we don't have witnesses ready. So maybe Wednesday noonish would be, and they might have to wait, and it might be the next day, but I'd rather that if we can.
And I assume we'll pick the jury Monday, start evidence Tuesday?
Correct. So what we'll do, I have just like this week, I have this docket every Tuesday morning. So we'll pick the jury at 1:00 on Monday, and then on Tuesday, we'll actually start trial at 1:00.
Okay.
So because I can't really skip this docket every week. And so, and then we'll go regular times, pretty much 9 to 5 the rest of the time. Okay?
Thank you, Judge.
Yes, sir. If you need anything else, I'm sure Mr. Nichols can help you out, or call the clerks if you need anything
We've
about
been in
how we do
contact, Your
things
Honor.
here or whatever. Okay, perfect. Thank you. We'll see y'all Monday.
Thank you.
Mr. Rojas, you've got Stephanie Moore. It's a sentencing. I took this off of something. I didn't put it back on. Probably one of my sentencings with a lot of things. Good morning, Mr. Rojas.
Good morning.
Good morning. You are Stephanie Moore?
Yes, ma'am.
And so Ms. Moore is here in cause number 11-12536, on probation for the offense of robbery. That probation was from December 8th of 2011. And we were here. She pled true to count 1, 2, and 3 in that motion. I've received an updated pre-sentence report. And has everyone had an opportunity to review that?
We have, Your Honor. I have, Your Honor.
That also includes a letter from Ms. Moore and a substance abuse evaluation as well that was done at one point. Do y'all have that as well?
I do, Your Honor. Yes.
Okay. So this is open to me, and I know we all understand the predicament that we're in. I mean, I have 2 choices. I can revoke, or it just goes away.
That's correct, Judge. And with a 7-year period of absconding, I don't know what the right answer is. I did look up, and I'll note for the court that she's been in jail 111 days since this motion was filed, or since she was apprehended. and a total of about 270 days on this case. I just think we can't ignore that period of just abandoning probation. I'm not advocating for a heavy sentence, but I think revocation is what we kind of have to do here.
I'm not
I
disagreeing.
understand if the court feels differently, but that's.
No, I don't think I do, because I mean, it looks like, I think that's just kind of rewarding some really bad behavior.
I understand that, Judge. I think from Ms. Moore's perspective, I mean, she had been going along up until 2017, doing relatively well on probation. She tells me that in 2017, when Hurricane Harvey came through, she just had 20 feet of water in her house, and she just spent the rest of that time trying to recover from that. I think
I did call my probation officer and try to get him to help, but he never even came out to my house or nothing. He didn't help me get any kind of mental health help or anything. And I called my old one, which was Miss Sally, and nobody came out for help.
You were on the mental health initiative caseload. You've been to the Franklin House South, the Oxford House for Women.
Yes, I was the president there.
Through the ATAR program,
Yes.
through Right Choice, through SafeP, and you were a resident at some point at the Jefferson County Women's Center.
Yes, ma'am.
Okay. I mean, that sounds like a lot of help.
I did. Well, I did all that and did good with all that.
Okay.
Yes.
Okay. Anything else?
No, Your Honor.
Judge, I think, I know the court doesn't like to do this, but I think there may be another option. Maybe it's a court, because one of the allegations that she's behind on her fees.
I'm not worried about that. I'm worried about 7 years of doing whatever she wants. And I understand that Harvey affected a lot of people, but then you get over whatever is happening and you go see your probation officer.
Okay.
You don't just stop
Yes, ma'am.
for 7 years. Okay, I'm going to find in that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of robbery. I'm going to sentence you to a term of 3 years in the institutional division of the Texas Department of Corrections.
Okay.
You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I need y'all to sign this. I'm going to, this is the trial court certification, if you'll get her signature, that she's getting a copy of that real quick, please. Thank you for being here, Ms. Joseph.
Thank you.
Sorry, I didn't ask you if you had anything else to say. So you're going to get a copy of this, which shows that this was not an agreement, and so you do have some rights to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Yes.
Good luck to you, ma'am.
Thank you.
Let's see, Nia Miller, Mr. Rojas.
No.
1 year, 1244. See, we may have a file. That's really nice. And she over Harvard.
All of a sudden, not all of a sudden, I'm sure I pushed a button, but now on here, it's not in lawyer order anymore. Well, it's just gonna, hold on. Now give me just a second. You know what? Nope, I'm ready. I don't know what I could have, how I did that. It's okay, I'll deal with it for now, and then we'll figure it out. Okay. Let me find it. Are you Nia Miller?
She's hard of hearing, Judge.
Okay, can you hear me?
Yes.
Okay, and are you Nia Miller?
Yes.
And will your client waive the formal reading of the indictment?
She will, Your Honor. It's actually a motion.
Oh, okay, of the motion, I'm sorry. Stand up, ma'am. Ms. Miller, in cause number 24-2227, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation January 14th of 2025 for the state jail felony offense of unauthorized use of a vehicle. And that was a 3-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed January 16th of 2025. And is that true or not true? Count 2 alleges that you did not provide verification of performing the community service hours. Is that true or not true? True. Count 3 alleges that you're behind in your court assessed fees. Is that true or not true? True. Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Miller is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to 1, 2, and 3 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I can't.
You cannot for some amount of time. If you have, you should read that document. It'll explain that to you. If you have any questions about it, you can talk to Mr. Rojas to find out how long it lasts and what all that rules are. But you can read that document. It has the information. All right, do you understand?
So with my time, with the time in, do I still have more time to do?
I don't know how much credit you get, but you will get credit for any time that you've been in custody that the law gives you the right to receive. They'll figure out that later today. The clerk will and send it over to the jail. Okay, you can go back with the bailiff. See Bryce Bordeaux to sentencing, Mr. Rojas. What is it on the motion on this one? Oh, no, I need to write on it. It's back in order now. No, it's not. I'm just kidding. It's not. I don't know either, but it's not. All right, so are you Bryce Bordeaux?
Yes, ma'am.
Mr. Bordeaux was previously in court, cause number 25 DCCR 0444, entered a plea of guilty to the second-degree felony offense of robbery. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yeah, Your Honor.
Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor.
No, Your Honor.
All right, Mr. Bordeaux, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those is going to be that you will be required to enter and successfully complete the JCDI program. Everything in here points to the fact that there is an alcohol issue. And so you're going to get treatment for that, and it will be part of your probation. You are not to drink any alcohol on probation. You will also be required for some amount of time to wear a scram device. That will show if there's any alcohol in your system. If there is, it's a violation of your probation. So you need to take advantage of the treatment and whatever they have to offer you. Do you understand?
Yes, ma'am.
If you do everything you're supposed to while you're on this probation, this is an excellent opportunity because you don't have a conviction on your record. And at the end of the probation, if you're successful, the case actually gets dismissed. You'll never have a felony conviction.
Thank you.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you become a convicted felon, and you could be sentenced anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
Okay.
Thank you, Your Honor.
Yes, sir. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Thank you.
Please flip towards this Tuesday jail docket. Tuesday jail docket. Flip.
Attorney didn't understand. I knew it. There's no way you could have changed that. Oh, I know where it is. Hold on. I got it.
It's still.
Show. Hold on. Hold on just a minute. It's showing the, I'm really mortified about this, the fact that I'm on Zoom. It's okay. I'll go to the show, reschedule show all here, show result of hearing. It's not giving me the, there should be another thing that shows not, it's showing you what's been rescheduled. I don't understand. Give me half a second.
Okay. Mr. Rojas, you got Bryce Bordeaux. Did I already do that? I just did that. Just testing everybody. Thank y'all.
He said he's not good.
I've never seen that more.
Mr. Radford, Corey Flemings.
Yes, ma'am. He still wants to go to trial.
I do want to put it on the record as a possible punishment.
Yes. And I'm going to mark it on here as well, that it would be habitual.
It's a UUMB, and I actually have a case upstairs right now as to whether or not that's enhancing. So
It is for.
At this point.
at this point, yeah.
Well, for purposes of Louisiana law, it's a state jail, they're equivalent to state jail felony, but the penal code here says we can treat it as a felony.
Correct.
Absolutely, but I think I have a case right now that says that violates the equal protection clause, and I'll advise the court when they make that decision.
Okay. All right. So Mr. Flemings, Mr. Radford has said that you have changed your mind and you want to go forward with trial. Is that correct in both of your cases? And I want to make sure you understand, and I know Mr. Radford has gone over it with you, that the way the law is right now, if you are found guilty and if those prior convictions are proven to be true, then you would be considered a habitual offender, and your minimum punishment would be 25 years in prison up to 99 years or life in each of those cases. Do you understand? And you want to reject that 8-year term and have your cases set for trial. Is that correct? All right, we'll get them set on the next available trial docket, and Mr. Radford will begin preparation for trial.
Yes, ma'am. Thank you.
Yes. Mr. Parker, you have David James sentencing hearing. Good morning. Are you David James?
Yes,
All right, so Mr. James was previously in court and entered a plea of guilty in cause number 25 DCCR 0522, which is the third-degree felony offense of collision involving serious bodily injury, and then entered pleas of true in the burglary of a habitation case, cause number 15-23545. Looks like there's an agreement for a 10-year term, probated for 5 years in the collision involving serious bodily injury, and then an agreement to extend the probation for 2 years and order the Safe relapse program. Is that correct?
Correct, Judge.
So I guess my main concern from reading all of this, a couple of things. Number one, he tested positive 2 weeks after completing Safe when he got out. And so that gives me obviously some concern. There sounds like there are some mental health issues that potentially special needs Safe would address. And so what I'm more inclined to do, if I'm going to follow this agreement, would be regular, not the Safe relapse, but the special needs Safe and go all the way through the program again from the beginning. I just think that
He has admitted that he needs the help, Judge.
So, I mean, here's the thing, Mr. James, most people don't get 2 shots at Safe and y'all have reached an agreement for that to happen. And I'm inclined to go along with it, but I want to make sure you understand this is it. I mean, if you don't, how old are you? 61 years old. It is time to get the tools that they give you at Safe and use them when you get out. It's easy when you're in custody, but you've got to use those tools that you're given. If you don't, then you're going to end up spending a lot of time in prison. Because if I do this today, you've already agreed to a 10-year term. Do you understand?
Yes.
Okay. All right, then I'm going to find in cause number 25 DCCR 0522 sufficient evidence to find you guilty, and at this time find you guilty of the collision involving serious bodily injury. Sentence you to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 5 years. I am going to order a $500 fine in that case, and that you follow all of the rules and conditions of probation, which will include entering and successfully completing the special needs safety program. In cause number 1523 545, I'm going to find that you entered your pleas of true to counts 1 through 7 and then 9 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke that probation. However, I'm going to continue you on probation, extend the probation period for 2 years. Also order that you enter and successfully complete the special needs safety program, and then obviously get out. You know what happens. You're on, as soon as you get out of safety, you're given tools to go to the whole treatment program that's outpatient. And so you need to take advantage of all of that. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed. And so you have waived your right to appeal. Good luck to you, sir.
Okay, thank you.
Mr. Parker, you've got Jacobe Lawrence. You okay over there? Yeah, it's missing a TRN, if anybody was wondering.
Yeah, you put up there. Oh, does you want the discovery, Judge?
Let's see, are we going on count 1 only?
Yes, you are. If I didn't mark it.
You probably did, I just haven't looked at it. All right, sir, are you Jacobe Lawrence?
Yes, ma'am.
And Mr. Parker, will he waive the formal reading of the indictment?
You will, Your Honor.
Mr. Lawrence, in cause number 25 DCCR 0656, the state has elected to proceed on count 1 only. It alleges you committed the third-degree felony offense of harassment of a public servant from March 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Lawrence is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of harassment of a public servant. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have also handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. Also, you've been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
Nicole Sanchez, Mr. Parker.
Pleading 1 dismisses.
Thank you. Good morning, ma'am. Are you Nicole Sanchez? Yes, ma'am. And Mr. Parker, will your client waive the formal reading of the indictment?
No, Your Honor.
Ms. Sanchez, in cause number 24, DCCR 1988, you're charged with a state jail felony offense of possession of a controlled substance from April 23rd of 2024. And how do you plead to that charge? Yes. Are you pleading guilty freely and voluntarily? Yes. And are you pleading guilty because you actually did what they charged you with? Yes. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Yes. Do you fully understand them? Yes. And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
So I know on a state jail felony possession, if it's a first, it's required probation. Is it not required deferred on the first? From my drug court days, I think it's,
You're right, Judge.
it has to be a deferred probation. It's required by law on a first possession. Okay, so with everyone's permission, can I make that change on their agreed punishment recommendation that it would be a 5-year deferred?
Yes.
Thank you.
Forgot all about that.
You don't have another felony conviction anywhere, right? Okay. Okay, so the agreement then,
Sorry, she does have my notes reflect 2013 manufacturing delivery in which she received 2 years probation. I don't know if that would count towards being prohibited from the deferred, which went into my calculation for offering a straight profession
Sure.
this time.
15 years ago, the time I was in college.
Okay,
Very young.
then I think it probably
Then it
would
can be
change,
straight.
that can be straight,
Right.
and that was, so
That's
I'm
correct.
going to change it back to what y'all's agreement is. Thank you, Mr. Coleman. Okay, so the agreement is that you would be convicted, there would be a 2-year term in the state jail prison, but that would be probated for 5 years. There would be a $500 fine. You would be required to follow all the rules and conditions of probation, and there would be a dismissal and cause number 24 DCCR, wait,
1118.
1118. Okay,
Yeah,
is that your
okay.
understanding?
There's
That means
the other case.
the fraudulent use or possession is getting dismissed. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Ms. Sanchez is not
No,
competent?
Your Honor.
And Mr. Coleman, other than that, is there anything else that you see?
That's the only criminal history that.
We'd like to waive the PSI, Judge.
Any reason not to?
No objection to waiving it.
We'll get a post-sentence report done. Ms. Sanchez, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you will be able to serve that 2-year term while you're out on probation instead of in the state jail prison. The other side of that is if you violate any condition of probation, you can be brought back into court and you'll get that 2-year sentence that you've already agreed to. Obviously, there's an issue if it's a possession case with drug issues. And so you will have an assessment done when you start probation. And as part of your probation, you're ordered to follow any recommended treatment programs. Do you understand? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Parker. Good luck to you, ma'am. And I will sign that dismissal now in 1118.
Jessica, thank you so much. Thank you.
Yes. Have any right to appeal. Hearing, we'll get you're guilty or not. You'll be waiving or giving up any right to years in the appeal. And it looks like the agreement that you've reached is for a cap of 50 years in the institutional division of the Texas Department of Corrections. I want to make sure you understand your case is set for trial next week. You have every right to go forward and have a trial and a jury decide 2 things. The first is to decide if you're guilty or not, and then you could leave your punishment up to them if you're found guilty. By going forward this way, you're waiving that and you're leaving it up to me. As long as I give you 50 years or less, then you're waiving that right to appeal. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Mr. James is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done by probation. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. And we'll see you at that sentencing hearing. You can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Your Honor, we did have a hearing at 11 with witnesses. I'm not going to need to call witnesses today.
Okay, let me take care of the rest of what we got and then we'll get to it in just a minute. And is Todd LeBlanc back there working on something?
He texted and he hasn't answered me.
Todd LeBlanc in the back?
We had Nerberto Frelow, and I've been informed that he is, his family's actually retaining someone.
Okay,
So it was just gonna need time so they can finish getting that in.
we're gonna reset Norberto Armenta to hire a lawyer. Thank you, Mr. Lewis.
No problem.
Ms. Holmes, you have Jamarcus Zarate Jones.
I'm gonna get a little complicated. They're doing a dismissal of the state's motion in that case to revoke. We have an agreement, I don't know if we need paperwork on this, for a 30-day sanction of the defendant and continuing on probation. The underlying criminal offenses have been either refused or dismissed. And then there is a criminal offense from Harris County that I've not been able to determine.
I've been informed that that will be disposed of as well with the dismissal, but it has not happened yet.
Okay, so I will sign the motion to revoke dismissal as soon as it comes through. I will order the 30 days upfront time or 30 days as a sanction as the agreement that he gets credit since he's been in custody on this. Okay, all right, we'll get that done. And probation, if I need to sign something, I can get that signed today for the 30 days. All right, good luck. Make sure you're on probation, follow all of those rules and conditions, or you're gonna end up right back in here. Okay, you're free to go back with the bailiff. Let's see, Jordan Thomas, his name.
I have filed a request to reduce bond.
Jordan Thomas,
Gordon Thomas. It's Kobe's.
it's Mr. Hoffpower's case.
Yeah, he said he's gonna dismiss it into it. It's, I found a motion to reduce bond on one of the sexual assault.
But I think
I talked to Kobe.
grab him, because I'm.
Okay, I'll hold it till he comes back in.
Yeah, I talked to him.
Oh, you did? Okay, good. Thanks.
Who's Andre Williams? What am I missing? I have a plea bargain rejection up here, but I don't have, all my pages are full up like I've got. Andre Williams? Bless you, bless you. I did reset them, so I don't know why. I'll just delete it. I don't know why he did that. I'm gonna delete that.
You had to do it for people.
Okay, yeah. So I think all I show then is Jordan Thomas and then the one that they have at 11, I think.
And I'm trying to find out about.
Todd LeBlanc, yeah.
So this is how old that Cosmo is on that rig. I don't know if the system will pull it up. I mean, I was here when that Cosmo was done.
And help them with the capital then, and they don't
I mean, can we put it on the tablet for the state, because Judge Brener did it? That might be the DA number.
I was thinking about that case y'all had last week, having this trial. How horrible they are, you gotta do it again. I don't know the fact, but I know it can't be good.
Mm-mm. What am I doing? What am I doing? Jordan. All right, are you ready on Jordan? Well, now where'd Ms. Holmes go? Is Brittany in the back?
I'm ready.
We're good.
She went outside some,
All right.
mine was reading pretty much. 11 o'clock.
Okay, hold on. Theodore Brisco, MTRP sentencing.
Hey, Luke. He's signing us right now for the.
Just tear it up.
Mike's in this. We're good.
All right, sir, are you Theodore Brisco?
Yes, ma'am, I am.
And Mr. Brisco is on probation in cause numbers 20-34535 and 20-36055. Motion to revoke were filed in those. They're both deferred probations, one for possession of a controlled substance, the other for evading arrest or detention with the use of a vehicle. Mr. Brisco was previously in court, entered pleas of true to counts 1, 4, and 5. We reset this for a hearing. I have received the pre-sentence updated report. Does everyone receive that report?
We have, Your Honor.
Yes, we have, Your Honor.
And go ahead.
I'm just going to let the court know, after reviewing the probation officer's report, I'm in agreement with the recommendation of ISF. I don't see a problem with that based on the information provided.
Okay, and no witnesses or with regard to any of the other
Not going
counts?
to need to, Your Honor. He pled true to one concern is that there is a drug offense pending that's not yet been filed, still waiting testing.
Okay.
We'll try to catch it as soon as we do, and either on concurrent or we'll deal with it. It just hasn't been brought to us yet.
Okay,
There's misdemeanors pending that
He's
we've
taking
discussed.
care of.
He's going to take care of it as
License here.
soon as he is done here, they'll free him up to be sent off.
What I'd like to say, just on his benefit, there was a charge of the possession of a controlled substance, and there was a pack of cigarettes that he picked up. And he says he picked up the wrong pack of cigarettes. It was a female that I think lived with him at the house, and they had issues. He had tested clean for 3 years, I believe, or for some time, and was even tested a couple of days after this. He said he picked up the wrong pack of cigarettes. She had been trying to get him in trouble to get rid of him. So just, not that it has an impact on this, but that's.
okay. Well, sounds like if somebody's trying to get rid of you, you just need to leave, right?
Go.
Okay. All right, Mr. Brisco, I'm going to find that you previously entered your pleas of true to counts 1, 4, and 5 in each of your cases, freely and voluntarily. Find those counts true. Find sufficient evidence to revoke both of those probations, but I'm not going to do that. It sounds like probation is willing to work with you and that they have reason to believe you can be successful. So I am going to extend your probation for 2 years. You will be ordered to enter and successfully complete the cognitive track of the Intermediate Sanctions Facility, the ISF program. You'll be on the high medium caseload and be required, obviously, to follow all of the rules and conditions of probation when you get out of ISF. All right. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
I congratulated Burbank on, he's always stressing me, so I said, congratulations on getting a jail time. But you got probation on one of the cases.
Oh.
He's like, thanks.
Uh-huh. Here's that.
Sorry.
Okay, Jordan Thomas. Okay, are you Jordan Thomas?
Yes, ma'am.
And Mr. Thomas is charged in cause number 24 DCCR 0487 with sexual assault of a child, and in cause number 24 DCCR 2178 with aggravated assault with a deadly weapon. And Ms. Holmes filed a motion to reduce the bond. Is that in each of his cases?
And just the sexual assault.
Which is $100,000 in that case presently. And I know this was recently filed. Mr. Hoffpower, are you ready to proceed on that, or do you need time? All right, Ms. Holmes, do you intend to call your client?
Yes, sir.
Mr. Thomas, please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You may proceed.
Thank you. Your name is Jordan Thomas, correct?
Yes, ma'am.
And Mr. Thomas, how long have you been incarcerated at the Jefferson County Correctional Facility?
9 months.
9 months. And in those 9 months, have your bond been set at $100,000 for the offense of the sexual assault?
Yes, ma'am.
And has your family during that time tried to inquire about helping you make bail, but have been unable to due to the amount of it?
Yes, ma'am.
And do you have any property at this time or anything of value that you could sell that could arise to the amount to be able to bond out at $100,000? Okay, and have you all worked diligently within these 9 months to try to get that done, but have not been able to?
Yes.
And are you asking the court to reduce your bond in an amount reasonable, and that you will abide by any conditions, and also whatever court appearances that you will be present, and that you will not be a flight risk?
Yes, ma'am.
So there was a bond forfeiture for non-appearance. That's why it's at $100,000 back in June of 2024. Why'd you miss your court date?
You got no answer.
Okay, you just didn't feel like getting up and coming? I mean, so she's asking me to reduce,
Transportation either, but
I can't hear you.
I had transportation. Stay home for. I tried to come, but
Did you call anybody? And
I called the bell ones coming in and told them probably wasn't make it. They told me to, turn myself in. The day of court, they wanted me to turn myself in
right,
after I missed the court there.
okay. So why didn't you, when did you do that?
I believe that's
Did you turn yourself in, or were you
No,
arrested?
I turned myself in
When?
December 19th.
So you decided between June and December, you would just kind of hang out and see if anybody caught you knowing there was a bond forfeiture?
No, I didn't know it was a bond for.
Well, if you don't show up for court, you don't get to just not show up for court and not have any consequences and just chill out and wait till whenever, right? Mr. Hoffpower,
I don't have any questions, just arguing.
what's your position?
My position, in light of 17.15, danger to the community, just on the original charge, which we're here today on sexual assault, I think the bonds would be high sufficient because of due to the allegations and due to the danger of children in the community. Also, I want to add, obviously, the court knows there's another case that is before the court in yours, and it is another serious, dangerous felony. It was committed while he was on bond and in bond forfeiture on his sexual assault case. So that he proved my point.
So
I know it's like similar actions, but it is.
the offense date on the aggravated assault with a deadly weapon is from August of 2024. And so, hold on, when was the bond forfeiture?
June.
July.
No, you said June, July.
June of 2024.
I don't know why he wasn't arrested
He was arrested for, I don't know,
Why,
because the police interacted with him.
there should have been a forfeiture and a warrant on the other case at that time as well.
Yeah.
So while you were out on bond is when this new allegation allegedly happened. Let me look at the PC on that one as well real quick.
August 18th.
Oh my gosh, I can't find anything on here. There was a warrant. This, I don't think he was arrested. This shows the Capia's return was from December, so that's when he turned himself in, probably on both of them.
I apologize if
Yeah.
I presented something different.
No, I'm just saying, I don't think he got, I think that's. Hold on a second. I can't read this. I gotta print it out. I'm printing the PC.
Oh, yes.
Okay. Your motion's denied. Based on the fact that you were out on bond and allegedly committed this offense, which gives me some concern, which is the aggravated assault with a deadly weapon. And you missed your court date and really have no good reasons why or what you were doing other than potentially getting new cases. I'm going to leave your bond at 100,000. You can go back with the bailiff. We'll get an announcement at the next court date.
Yes, ma'am. Thank you.
So anything from Todd?
Is that one of those little phones? He's got in his ear?
No idea, Judge.
Good
morning, Judge.
morning. Who do you have, Meg? Meg, who do you have? Oh, is that, are you Langston? Yes, sir.
You've done.
What do you carry? Is that phone?
No, that was.
Those are talks. That your earphones? What you listening?
That's. You hit it?
I seen it turn.
You off the shade. But no, he's done. My other two cases, Judge, the clients didn't, I didn't have a show client. I called the names of both of them and nobody answered.
All right.
But he's a plea.
Okay, well, let's call these out and make sure that they didn't show up. Latanya Renee Bryant is called. Cause number 25 CR 445. Latanya Bryant. There is no answer in the courtroom. I asked the bailiff to call into the hall for Latanya Renee Bryant, please. She's got a warrant, another warrant.
Yeah. And got another indictment coming out.
Yeah, she just got indicted last week, 2 more charges.
Did somebody tell her that? Or?
Well, they're trying to with the warrant.
And the other one was Mingo. I
Hold
called
on, let me take care of Latanya Bryant. What is her bond?
I said Mingo hired an attorney, so that's.
Latanya Bryant has failed to appear today. Her attorney is here, but she is not. Her bond will be revoked when the computer decides to work.
Yeah. One minute.
Listen,
Her bond's $8,000.
okay. She's failed to appear. Her bond is double, as we normally do, from $8,000 to $16,000. Plus, the defendant must have a GPS device as a condition of bond, so we know where she is when she's not here, when she's supposed to be here.
Okay.
All right, that's that one. And then the other one.
Hire a lawyer name
is, who else was not here?
Mingo hired his own lawyer. That's what Mr. Laird said.
Brandon? Oh, that was reset. Yeah, because he hired for it. There's somebody else that wasn't here.
That was it.
Was that it?
That's it. And good.
Okay, you were Mr. Nelson?
Yes, correct.
Here. Let's look on the phones. Fernando. Yes, sir. Nelson is called in 24 CR 591. You were here with your attorney, Mr. Adams, and the state's attorney. What are we doing today?
Probation.
Oh, this.
Try to shoot yourself with a pen?
Man.
It's leading process.
Things are not, I feel like I'm in a Twilight Zone episode right now. It's missing really everything's. All right, does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary? Hello.
Yes. Yes.
Yikes. This goes 3 pages long. All right, paragraph 1 alleges in summary, sir, that you, Fernando L. Nilsson, also known as Fernando Lamas Nilsson. Really? That's an actor's name.
Yes, sir.
On or about December 30th, 2023 in Jefferson County, Texas, you committed the state jail felony of theft. And it states you stole perfume.
Yes, sir.
Not cologne, perfume. Oh, it was an anniversary present. Got to pay for this stuff.
Yes.
All right. The indictment, though, in paragraph 2 goes on to allege that you have several theft convictions, 2 or more prior theft convictions elevate. And if you stole a pack of gum, it's a felony from here on out. So paragraphs 1 and 2 constitute a state jail felony, which means if convicted, you face a term of not less than 180 days or more than 2 years confinement in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range here?
Yes, sir.
An agreement's been reached where you would be sentenced to
5 years.
5 years, probation for 5 years.
And $500 fine. But there was no restitution. They got, I think they got the loan back.
Well, no, but how are we doing that? I just read him the punishment range was up to 2 years.
Yes, sir, but with the enhancements,
Nobody said anything about enhancement. So we're using the enhancements
apparently, Jeff is.
because you got the punishment range here. This is a state jail felony.
Yeah, but it's punishable as a third degree.
Disposition.
Punishable as a third degree. Did you sign 2 years probation for a felony?
No, he signed the state jail felony papers.
Okay, but.
Well, that's what's in.
Yeah, I mean, it is a state jail punishable as a third degree, so, but we can refill out the paperwork we need to do.
I know it's a state jail felony, but it's punished as a third degree felony. There's nothing in here that shows that it's third degree felony.
Okay.
We got to put that in, right? That's what y'all want to do?
Yes, sir.
Yes.
Okay. Where? Asterisk this and put it down here.
That's not fine well there. That's what I was looking at.
I use the state, you are going to say, so it's fine. Cause you state jail, but
I didn't sign the paperwork, so I didn't notice it. Just. That's fine.
that's easy use.
All right. He's admonished.
Yeah.
You're gonna have to put a new one. It won't work. I'm trying to do something here that it's not letting me do.
You want to do another form?
We can redo the format here. It can be punished. They can just admonished.
Oh, no.
He's trying to, but it's not letting him.
If you touch the pad, it erases. If you just touch it.
Yeah. Yeah, I know. It's super sensitive. We
All right, paragraph 3. And 4 allege that paragraph 3 alleges, sir, in the indictment that on September 8th, 2006, in cause number 98342 in the 252nd District Court of Jefferson County, Texas, the lady next door, you were convicted of unauthorized use of a motor vehicle, a state jail felony. And paragraph 4 goes on to allege that on February 6, 2008, in that court, in cause number 071240, you were convicted of the state jail felony of burglary of a building. Do you understand what you're charged with then in paragraphs 1 and 2, which constitute a state jail felony because of the 2 or more theft convictions along with this new theft charge? And then 3 and 4, those prior state jail felonies, 2 or more state jail felonies, bump your punishment. It stays a state jail felony, but the punishment is enhanced or increased to third degree felony punishment. It's a state jail felony on the books, but you're punished as though it was a third degree felony, which means you face no less than 2, no more than 10 years confinement in prison and a fine up to $10,000. You get punished for the commission of the crime and prior criminal behavior. That's the equation that is used in criminal courts.
Yes, sir.
This states that you will be pleading and guilty to all of this and true to all of this, sentenced to 5 years in prison, and that would be suspended and you would be placed on regular probation, which can be up to 10 years in length. You understand?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Okay. How do you plead to paragraphs 1 Paragraph 1, let's start off with that one. Paragraph 1, charging you with theft, in this case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Paragraph 2, which alleges those prior convictions of thefts, which are, there's 7 of them, but there's the first 2 we talked about, those thefts out of in 2002, 2004, County Court of Law 3 of Jefferson County, Texas, in 2002 and 2004. Are those allegations true and correct as they are alleged?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
And finally, paragraphs 3 and 4, those prior convictions we talked about, are those true and correct? The state jail felonies out of the 252nd District Court back in 2006 and 2008, are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to all of this voluntarily and because it is true as it is alleged?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Let me ask you at the top, look at your signature at the very top. Is that the way you sign your?
No, sir. I must have been holding.
Here, yeah. You got to use that one. That's easier to not smudge.
Not missed the book.
You don't have to do anything.
Oh. He finished it.
Did you sign this document voluntarily, knowingly, intelligently? Are the contents true and correct?
Yes, sir.
And did you discuss this with your attorney?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, the state you were mentally competent to enter your guilty plea. It's truly and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crimes charged and any lesser included offenses and the prior convictions we discussed in paragraphs 1, 2, 3, and 4. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and totally satisfied with the representation provided by your lawyer.
Yes, sir.
All of this is true. It states so help you God. States Exhibit 1, follow the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement. If nothing further, I'm going to find you have pleaded guilty to paragraph 1 and true to paragraphs 2, 3, and 4, the prior convictions which constitute a state jail felony punished as though it were a third-degree felony. You were doing this voluntarily, knowingly, intelligently. There was supplemental information presented out of State's Exhibit 1, where you knowingly, voluntarily, and intelligently gave up your rights and have pleaded guilty and true to this state jail felony punished as a third-degree felony. You were doing this voluntarily, knowingly, intelligently, and upon discussions with your attorney. I now find you guilty beyond a reasonable doubt of the state jail felony. I'm following this agreement. You hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. That will be suspended, and you were placed on a regular probation for 5 years. You will be fined $500. Is there restitution in this? There will be other terms and conditions of probation which you must follow. Also, we're going to order you to take and successfully complete a theft prevention class.
Mm-hmm.
And you're a little old to be learning about theft is the wrong thing and it's dishonest. You know right from wrong. You just have to choose to do it. What are you going to do? The right thing? Good for you. Here, see the probation officer.
Thank you, Judge.
Yes,
Appreciate it.
Okay.
No problem. Thank you.
See you, buddy. What do you have, there, little buddy?
You're right, I've got Andre Gillery.
That's on the 9:30 docket.
Come on up. Is it all signed up or what are you doing? Yeah, come on. Yeah, Mr. Gillery, you need to come in front of this lady and y'all got to take care of some things right here. Let me,
Gillery, please raise your right hand. You swear or question, tell the truth, the whole truth, and the truth, so help you God. And that's your right hand, friend. Place it flat there.
Is
There, one more time.
Janaya Delahousse here? That you, have you seen your lawyer? That's Mr. Grove. Have you talked to him at all? Okay, let's wait. It should be Alan Lofton. Are you here? And again, that's your lawyer as well. You haven't seen him, have you? No. All right. Y'all ready? No. Andre Gillery?
Yes, sir.
'22 40681 is called. Andre Jamal Gillery, present with Mr. LeBlanc, his attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that from on or about September 1st, 2021, and continuing to on or about July 27th, 2022, about a year, this states that you committed the third-degree felony of theft. Do you understand what you are charged with?
Yes, sir.
This is theft of money. Looks like.
Yes, Your Honor.
What was that?
It was $32,831.02 from Cracker Barrel here in Beaumont.
Did you work there?
Yes, sir.
Okay. It's not a good thing. If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty based on deferred or unadjudicated probation for up to 10 years in length. You must pay restitution in the amount of $32,831.02 to Cracker Barrel in Beaumont. Is that your understanding of the agreement?
Yes, sir.
There will be terms and conditions of probation, which are normal and customary for this, including, like the guy before, a theft prevention class that you must take. You know it's wrong, but we help burn it into your memory that it has consequences. If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
So,
show you what's marked as State's Exhibit 1. Help me. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? And are the contents true and correct?
yes, sir.
State's Exhibit 1 tendered into evidence without objection, admitted. Among other things, the state you are mentally competent to enter your guilty plea freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offense. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All through, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report, way.
Yes, we do.
Okay, I'm going to follow this agreement and find you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from your sworn admission of guilt here to find you guilty beyond a reasonable doubt. I now find I could find you guilty beyond a reasonable doubt at this time, but I am going to defer any finding of guilt and place you on deferred or unadjudicated probation or 10 years. You do well, it gets shortened to 1/3 of that. The most important thing is this money that is owed. How is that going to be paid back and how much you're going to do per month?
As much as I can.
Then, yeah, I need a number. If you're unable to make it, we can amend it, but I need to know an idea because this is a lot of money.
So maybe you get up to 1,000 a month.
Where are you working now?
So right now I do like odd jobs and then I drive over to. And I make about 700 a week.
How much?
700 a week.
Okay, so that's 28. That's between 2,500. Why don't we do this? Well, why don't we start out with 1250?
Okay.
Okay. And that still is per month is not going to get you. Can you do 1,500?
Yeah.
Okay, then 15 gets you halfway in a year.
Okay, we'll go.
All right. In the probation report, in this probation order, if we can change this when he signs it to a minimum of 1,500 per month to be paid back, and that still gives them 2 years. But I can tell you that the key also to getting off of probation early is good behavior, but when you pay restitution back, that means a big difference to me and the victim, and you get rewarded. You sense what I'm telling you?
Yes, sir.
Is it reaching out there because I'm telepathizing?
Yes, sir.
Okay. All right. Please see the probation officer. Thank you. You know, it's, I don't know what to do about it. Truly,
They're not.
they're not, but. Okay, let me go over this. Mr. Villahusi and Alan Lofton, y'all are here. Alan Lofton? Yeah. And is Matthew Graham here? Come on up, Mr. Graham. Yeah. Mr. Boyd, when you get a second, I think you're the prosecutor on this one.
Yes.
You're Matthew Graham?
That's
All right, you are charged here in 24 CR 2425 with the 3rd degree felony of stalking, which carries with it up to 10 years in prison. What are you doing about getting a lawyer?
Today,
You're gonna get one today?
Your Honor, I respectfully request a continuance to obtain legal.
Yeah, Dave. I love your formality. We're gonna work with whatever you need to get the attorney. You have a reasonable amount of time. Do you have somebody in mind?
No, sir.
Okay. Have you ever been arrested before?
Yes, Your Honor.
All right, here in Jefferson County?
No, Your Honor.
Where?
Montgomery County,
Okay, for what?
2014 possession of marijuana.
Yeah. What happened in that case?
It was this money.
Did you do something, take a class or something to dismiss it?
Revocation.
It was deferred?
Yes.
I think this is going to be a more serious matter. You're looking at up to 10 years in prison here.
Yes, Your Honor.
So are you employed somewhere?
No, Your Honor.
How are you going to hire a lawyer? They cost. Do you have money to hire a lawyer?
No, Your Honor.
All right. We're going to get you to fill out one of those indigent forms. In the state you're in, you're indigent, which means you can't afford one, but you need a lawyer to get in the game. People who can't afford them, we help them until they can get on their feet. There's the document. I want you to fill that out when you're through. Let me know. You're going to have to swear in front of her that it's all accurate, and then we can get a competent lawyer in the indigent collection of lawyers that help the indigent people, help you along for a little bit.
And Your Honor,
What do
I
we?
would request if he doesn't have an ankle monitor, that he have an ankle monitor. In this case, I particularly agreed because he was.
All right, that's, yeah.
Yeah, there's some.
Do you happen to have an ankle monitor on you by any chance? Did anybody order that?
No, Your Honor.
Okay. Well, it's a GPS device. And the problem with this is we want to make sure that you don't backslide, as it were, make a mistake and do something that is similar to what you're charged with in this case. you're gonna have to get a monitor, and it costs you, we'll help you the probation office knows where to get those. They know all the information about how you can get them and what it's gonna cost. But you've got 48 hours to get one on. And if you don't, you need to come back here and talk to me. Because you can't be ambling about without one of those as a protection, not only to you, to me. Because you're on my watch now, and what we don't want is behavior repeated. We got to fix the mess here and don't do it ever again. But this is. And you can't have any contact with the victim, by the way.
Yes, sir.
That would be catastrophic. You would stay in jail until this thing ever got finished. Let me ask you another thing too, is are you seeing any psychological expert for something, what I'm reading here? Have you talked to anybody about
No, you're not.
issues that you might need to address?
No, you're not.
You need to think about that, because I'm going to order some things if you don't come up with an idea, because we don't want this kind of behavior repeated, do we? No. You know what I'm talking about. I'm not going to spill the beans because it's an embarrassing thing, like a lot of cases here. But this isn't going to happen again on my watch. If you would be severe if you were accused of something like this. Whatever motivated you for this, you got it. It's a sudden stop in that direction on my watch. Do you understand?
Absolutely. Right.
Okay. All right. I want him back in 2 days just to tell me where we are on the GPS device.
Yes, sir. You want him to fill this affidavit out there first.
Yeah, and then what we're going to do is we'll reset it, get you a lawyer appointed to help you, and move forward to fixing whatever caused this. And that's what we do, is we help people fix their mistakes. Anyway, fill that out, and when you're through, come up here and sign in front of that lady. Thank you.
Yeah.
DeMarion Kelly, come on up.
You can sit in the challenge and throw it out, and then come back up to me when you're done.
24 CR 1673, you were charged with theft. State jail felony, which carries with it up to 2 years in the state jail. And what you need to do is conduct yourself better. Not the least of which is don't wear a sign. I don't want to even look at a sign on your bill. Would you wear that to church? Now, we're not church. Would you wear that to church? You would think about wearing that to church? Well, you're wrong. That's inappropriate. That's not honorable. We don't want signs. We don't need things plastered. Just look at everybody. Look over there. You see anybody else wearing anything like that? Well, if you don't have clothes, look, I'm one of the partners in Salvation Army here. Go to Salvation Army. They'll take care of you. They'll give you some clothes that you can wear in sport. Okay, so don't wear something like that. But go to the Salvation Army. Do you know where it is? It's not far. It's on Interstate 10. And tell them that I sent you over there. I'm on the board. And they can get you some clothes for people who uh, um, aren't able to afford it. This says your address is on Jonah's Way in Houston. Is that right? Well, what is your address? Is it in Beaumont? What are you doing here in Jefferson County? No, you committed a crime here. Why were you here?
I'm saying I don't know why I'm here. I don't know what for. Like I got arrested in Harris County. They told me I want out.
Says you with a driver's license that you had, you're Demarion Kelly, 3/24/2004. That's your birthday. You made a rental contract with Jack Rentals, JAC Rentals on March 29th of 2024. And it was for a utility trailer and a stump grinder. And you used a Visa credit card and it was not returned. And thus the equipment that you had rented was never returned, and you owe these people back. That's what they say. And it says your name of Jonah's Way, Houston, and it describes you to a T. You don't remember doing this? Okay. Carries with it up to 2 years in the state jail. So, like the guy before you, we're going to need you to fill out an indigent form so we can get somebody to help you out. So fill that out. When you're through, I'll get back with you on it. Okay.
Okay.
Zachary Poole.
You
Is Zachary Poole here?
Gallery.
Zachary Poole, 23 CR 1044. There is no answer in the courtroom. I ask the bailiff, please call into the hall for Zachary Poole in 23 CR 1044.
Judge, he did call the office this morning, said his car broke down, that he would be late. That's all the information.
Oh.
Okay.
He's here, Your Honor. You're Zachary Poole? Come on up. You are charged here with burglary of a building, a state jail felony, which carries with it up to 2 years in state jail.
Yes, sir.
Are you getting a lawyer?
No, sir.
Why not?
The job that I talked to you about when I came for the first time, it never went through, and I just got a job at Track Supply.
At where?
Track Supply.
I can't understand.
Tractor Supply.
What are you doing?
Freight maintenance.
How much are you making an hour?
11.
Here, fill one of those. We're gonna get you an indigent form. You fill that out, okay? And when you're through, come on up and we'll take care of that. Or what is your address? Is it still in Winning?
Yes, sir.
On 12480?
Yes, sir.
Okay.
You have a seat in the gallery.
And actually, hey, Zachary, you've got two cases here. It's a burglary of a building and a state jail felony of theft. And so we're gonna have to deal with two cases.
Yes, sir.
All right. All right. Just fill that out. It'll be used for both. Janaya Del Hussein. And also Alan Lofton. David Grove is your attorney, correct?
Right.
I hadn't seen him either. Have you talked to him at all?
So one time, I heard.
All right. We're gonna find out and try to figure out where he is. Stand by. Thanks. Knowles and Dunn.
Which one, the 9:30 dockets?
I think this is what this is.
Thank you.
Oh, honestly.
Yes.
They've already took care of Nolan.
Yeah.
We've got, Reagan, Analdi was here.
Yeah, she's here somewhere, Judge.
Edwin Jones, is Edwin Jones here? Tom Burbank is your attorney? Yeah, I don't know where he is either.
He's here, just, he showed up, I don't know where he was.
Where is he?
He's
Looks short today. Is he standing up in the chair? I don't even.
He's taller than that, Judge.
Welcome. Ronald Cameron.
Yes, Judge, she's here.
Where is he?
Cameron.
Third degree felony of DWI, as you know, carries with it up to 10 years in prison. What are we doing today?
Judge, I'm still waiting on my media request to be fulfilled and then I'm.
How much time do we need?
4 weeks, Judge.
All right. We set 4 weeks, please get a resetting. Jennifer Gamble from that lady. Jennifer Gamble is called. There is no answer in the courtroom. I ask the bailiff to call into the hall for Jennifer Gamble, please. It's like 3 cases, 24 CR 2355, 2356, and 2357. Yes,
It's not here. She's with her.
there's no response to the names called here in the courtroom and no response to that name called out in the hall. Defendant is failed to appear. And warrants shall be issued for her arrest. What are her bonds in these, please?
So on the 2355 case, it's $20,000.
Okay, that is revoked and it is now $40,000 plus she must have a GPS device as a condition of bond.
On the 2356, it is also $20,000.
It is doubled to $40,000. For failure to appear. And 2357.
Awesome. $10,000.
$10,000. So it is doubled to $20,000. That's $100,000 in bonds, plus a GPS, plus home confinement. As conditions of bond. All right, and those are the orders of the court. Warrants are issued for her arrest. I have Joanna Glover. Was that recent?
Judge, it was. She is currently in custody. She has 3 cases pending before the grand jury next week. So we will have more information on those once we get an answer on whether those will be indicted or not.
Okay, so that one will be, here's the Gamble file. So on
Glover.
Glover, that will be reset. How much time did you say? 4 weeks?
Yes, that should be fine.
Okay.
She's before grand jury next week.
Okay, and then Austin, I'm sorry. Did I do Vicky Harmon already?
Judge, that's reset. She's in the hospital. She is in the hospital, Judge. And I'm talking with Mr. Laird on how to resolve that. She's got serious health issues.
Austin LaFleur.
He is here, Judge.
You're Mr. LaFleur. Okay, this is an announcement. You're here with your attorney, Ms. Minaldi. You're charged with 3rd-degree felony of injury to a disabled individual. Well, that never reads well, does it? Your dad? Who's your father? You have to speak out. Okay. Are you still in Poteet?
I know, sir. I live with my grandparents in Leander, Texas, 6600 Acacia Drive.
Hold on, you have, because I had 1412 before. So give me the new address.
6600 Acacia, Acacia. ACIACIA.
And is that a drive?
Yes, sir. Leander, Texas. LE.
Leander?
Yes, sir. LEAND.
What's the zip there?
78641.
Okay. Okay, this is as of this date. Okay, we have corrected. Okay, go ahead.
Okay, Judge, he is clearly coming from out of town, so it's been a difficult meeting with him, but he is going to review the
Where are we
media
coming from out of town?
associated with this case. If we could get a 4-week reset for him and I to talk about what that media looks like. And then for Mr. Boyd and I to talk about the case moving forward. I think that there's some mitigating factors that we should discuss in terms of a resolution.
Okay, the first, granted, you don't have any contact with this man right now.
Sorry.
That would be,
In your honor, I've
catastrophic if you did.
Yes, sir. And I-
Don't, if I found out,
Yes, sir.
until we can get this figured out, no contact with him.
Yes, sir.
But it's your father.
Yes, sir.
You gotta fix that.
Yes, sir.
Judge, I've spoken with the complainant and he's advised me that there hasn't been any contact right now, that the defendant's actually been doing very well where he's at. And so I think we will have this
When's your father
resolved.
Yes, sir.
And this has to get
And we need a
repaired. This has to get repaired. Only get one dad.
Yes, sir.
It's the way nature is. You gotta make the best of it. Wish mine was around. You know, man, I lost him. And then there's nothing you can do about it if you don't have it fixed before something like that happens.
Yes, sir.
Because it's forever. Fix this.
Yes, sir.
All right. 4 weeks.
Yes, Judge.
Okay.
Thank you.
Yes.
You set up. Yeah.
Okay, Julio Ramirez.
Graham, I need for you to sign out there for me. Yeah.
Okay, we are here on cause number 24 CR 1277, Julio Rolando Ramirez. And I believe Ms. Minabi is your attorney. It's you know what you're charged with in this 3rd-degree felony?
Yes.
Failing to comply with sex offender registration. Have you complied?
Yes.
You right now, you're not.
Yeah.
What we're gonna do, I'll just, you know how you handle these, you know, we just do something so that, have you ever, does he have a criminal history? Other than
Nothing else
this?
than the underlying law.
All right, well, this is, we generally, you know what we generally do on these, give them, you know, put them on a,
It's Miss Staub's case, so I would like to talk to her about
Yeah.
that, or potentially considering a cap of some kind. I just have not been able to do that since she.
Shop or TDC.
Yeah, and she
Oh, she
did it over
did?
TDC.
What's that?
I don't know. I'm not familiar with the case enough. Yeah, I think she put a note in here that he had a prior failure to register that was dismissed. So.
well, but that wasn't a conviction.
It was not a conviction, that's correct, Judge. But I would like to talk to her about that
Sure.
and see if we could maybe.
3 weeks, good? Okay, here we go. Reset 3 weeks, get a reset, thank.
That you're.
And make sure that you are registered at all times. Congress is worried about. Scott Caddis, you're looking at 10 years in prison. You know, you don't want to worry about that, do you?
No, sir.
All right, yeah, good.
I'm sorry, Judge, what are we?
Reset 3 weeks. Monica Ritchie. What are you doing on this one?
I'm still waiting on my media.
What's taking so long on that stuff?
I think it's an issue with my system, Judge. For some reason, she didn't pop up on my radar until later. I think that it's my fault, but I have requested it. I should have it sometime this week. If you could just give a shorter reset, I should be able to.
February.
Yes, that's correct. This is actually the first contact that I've made with it, so I don't know if I was.
Next time,
2 weeks, 3 weeks?
3 weeks, good?
Yes.
Good resetting. And you shouldn't have a, do you have like a,
Interlock.
An interlock?
an interlock device?
No, sir.
You don't drive a vehicle?
Or me, no, drove her.
Okay, if you ever drove a vehicle, you have to have an interlock. If you found out otherwise, there'd be severe consequence. What happens if we catch somebody like that? Even if they're not intoxicated, but if they order to, they sit in jail until this thing gets finished.
Can you sign that second?
We don't. Okay.
Thank you.
How much time did you say?
3 weeks.
You got it. 3 weeks. Okay. Thank you. Jose Rocle,
He requires a translator, Judge. If I could hold him to get a conversation with him.
I guess Spanish.
Yes.
Where is he?
Is here.
That's him?
Yes.
Okay. Un momento.
Why she?
Is she the translator?
No, Miss Burge is here.
Miss Burgess here. Okay. Renata Taylor.
She is here, Judge. I just got the portal discovery released to me this morning. If I could have a 2-week reset on her to discuss with Mr. Boyd, I think we'll be able to figure out.
Okay, this is 235725, reset 2 weeks at the request of the defense. Thank you. Nathan Davis is pageant. Okay, go back to you.
One.
Who is
Rocha, Jose Rocha.
Yeah, okay.
Thank you, Judge. Yes.
James was here.
Sure. That last one, I believe, we were informed that he may be deceased, Mr. Durwood.
Who?
Mr. Durwood. So checking into that.
Durwood Stanley.
Sheriff's office called us this morning and said that
Okay.
he
Is deceased.
Okay.
Yeah, all right, we don't know for sure, right?
Well.
So we don't want to say anything.
Well, we.
I mean, we don't want family or something.
Sheriff's office, but we don't have anything other than that phone call.
All right,
So as soon as we verify that, we'll dismiss the case.
Rigoberto Gonzalez. Rigoberto Gonzalez, and this was an out of town attorney here. There is no answer. I asked the bailiff to call into the hall for Rigoberto.
I think that's being reset.
It's odd that the attorney wouldn't be here.
No, there was an email early on that said that that he had worked out a deal with, I think Mr. Eckhart to reduce this. I could not find the file yesterday, so
Did somebody tell him not to come though, do you think?
It's still, I still show it set on today, so.
Okay, well, he was emailing, I don't know who the email was including, but I know that.
Well, there's a Cynthia Solis is the attorney.
Talk to Ellie.
Then that should be a female.
Ellie told him we were gonna reset the attorney
You
and
have to sign this back page for me.
try to get this figured out.
You have to sign up at the top.
Yeah, we got this Rigoberto, we have Laura Gonzalez not here, and a Cynthia Solis is the attorney. And Mike says you might have told them.
2 week word.
Okay, but it's done. And to for how long? Okay, all right. Okay, bye.
I think it's being.
It's been reset.
It's being refiled as a misdemeanor, so we just need time to find out how long to make sure that's fair.
And Logan Birdsong, and that's with Lane Walker, who's always here.
Mr. Walker is ill this
Oh,
morning.
okay. Well, we don't want to
Right.
make him so.
So we moved his case.
You're
yesterday.
Logan Birdsong. Come on up. To win. Your attorney's unable to be here. We're gonna have to reset it, okay? 4 weeks.
Yeah.
Oh. And everybody's got something right now going on there. But anyway, just get in line there and she'll reset it.
No.
Thank you. Gerardo Galvin was reset. Lawan Kirk,
Judge, that was another one of Mr. Walker's. I do not believe that the defendant will be here this evening.
why not?
From my understanding that she was, that something was worked out with Mr. Walker and she wasn't gonna be here this morning. She's in a wheelchair.
Okay, but it was, defendants normally have to be here, but did somebody, do one of my staff say they didn't need to be here?
At least the one that told me that she wasn't gonna be here. She's in a wheelchair. It was worked out with Mr. Walker. But I'm not
Okay, let me see.
entirely sure what the plan was. For your sake.
Yeah, I have Lawan Kirk who's not here. Okay, so Kirk's absence is okay, is an all right absent. Thank you. All right, bye. All right, so Kirk will be reset, and Jose La Rosa was already reset. Burbank, you have something?
Judge, on these other two defendants that were filling out affidavits, how long do you want to give them?
4 weeks.
4 weeks, okay.
I had Mr. Jones, Your Honor, an announcement. That was a very complicated case, Judge.
Yes.
Edwin, where's? Yeah, come on up. I don't know why we have these, because every one of these 8 pages was all reset. We did get one thing really moved. I don't know why. Or just jump over to dispositions or not.
A couple days.
That's really, because this is just, we're just doing paperwork and just making paper and nothing's getting really moved.
Yep.
Edwin Jones, yeah, right here. And it's an announcement. And go ahead.
Your Honor, Mr. Eckhart and I were getting to a resolution of this that probably would take this out of court.
What about now?
Well, I don't know whereabouts it's hanging at, so whoever is going.
4 weeks.
Yeah.
Is that gonna be good?
Assigned to it, so I can bring them up.
Okay.
Right?
Yes, sir.
You know, kind of, whatever you say.
Can we scare it?
Yeah.
Is Fernando, we took care of Fernando Nelson, right? Yeah. Then I've got cases with David Grove, and I haven't seen Mr. Grove at all. Janaya Delahousse and Alan Lofton. Come on up. We're gonna reset your all's cases for 2 days, for 2 weeks, 2 weeks, okay? Please get a reset. Thank you.
I'll write down the X.
Okay. Then I have Matthew Graham.
I'll see you in the video.
That was reset? Yeah, that's up. And Marion Kelly. Yes. You got your stuff done?
Talk to you soon.
I'll look at Sonny's nose.
Hold on, let me get the key. We'll raise that. And then I'll-
It's just store to play. So don't make up.
Then finally it was Zachary Poole. We took care of that.
Yes, sir. That's.
Yeah.
Which one is the attorney?
So I was like, oh.
What is that? The sign right there on the X for me?
Send them over. And he said, well, the chicken thing was, that you'll just have a resign, it's just, it's the long way. What he did about all that, you present.
There you go. Thanks. You're welcome. Right there on the X.
No, that doesn't sound like much of a plan to me. I like prison or probation, but those are plans.
No, you got, boy, have you forgotten about
Yes, I have. And when, if I ever switch sides, I'll forget all about this too.
surprise.
Huh? I just like a big bold written writing on front of the file folder.
I'm warning you.
This top secret stuff.
Yes, so if you want.
Warning.
There is a lawyer referral service.
Will Robinson, yeah, Will Robinson.
Any secret stuff. Exposure unlawful. Got some other flushes. Well, doesn't have an exit.
Yep.
No, that smells dismissal all over. Right here.
Yeah, we don't listen to feds. I just take that out and just go about my business.
As long as you don't.
Oh.
They won't prosecute anything.
Yeah, states that.
Really got juicy stuff.
See y'all there.
Say what you want.
I'll do this.
And then,
Okay, Mr. Kelly, please write your right hand.
we had
Or affirm this information.
James Patchett's doing something.
Okay.
He was in.
Yes, Your Honor, he's up there reviewing a video. I think he's gonna ask for a reset. He's looking at the video. and
Why not? Everybody else did.
the defendant,
We didn't get squat.
Move on.
We didn't get squat done here today. 8 pages, nothing. No, really. Nothing. 2 things, that's it. That's not gonna
Really
pay for the rent.
Okay, I need you to sign right there for me.
So,
Okay.
I've got,
Give your attorney a couple of days, okay? He's not gonna have any of the information until we send it to him later on this week, okay?
and then
This.
versus Siobhan Vincent. Cases number 25F30011, 25FB1003, and 25FB1002. Counsel, please state your appearances for the record.
Good afternoon, Your Honor. Katie Rosmersky for the people.
Good afternoon, may it please this honorable court, Kareem Johnson on behalf of Ms. Vincent, who's standing in my immediate right.
All right, state your name, please. All right, thank you. You may be seated. All right, date and time set for preliminary examination. Are the parties ready to proceed?
People are, Your Honor.
You may call your first witness.
Your Honor, may I place some preliminary items on the record? Thank you very much. Court having called all three cases, my assumption is that the court is comfortable with us running all three prelims together as they're sort of part and parcel of the same investigation.
My understanding is that that's what we were going to do. I don't know, Mr. Johnson, did you have any objection to that? I thought we dealt with it the last.
No objection, Your Honor.
All right, very good.
Wonderful.
That's fine.
Thank you, Judge. Also placing the court and counsel on notice that we do not intend any longer to proceed on with count 4 RNC of a motor vehicle on file number 25FB1002. Also would like to place the court and counsel on notice that we will likely be seeking to add a count 11 of armed robbery, which is MCL 50.529, and that would be as to file 25F30011. That is the homicide file, and that would be to comport with the anticipated testimony and proofs, and also to comport with the charges that were bound over for the two co-defendants in this matter.
Gotcha. You said a count 5?
11, I think.
Well, no, that was count 11, but previous to that, you said you don't intend to proceed on count 5?
Count 4, Judge.
Okay, count 4.
I said 5, I misspoke.
Yeah, I don't have a count 5, so. All right.
And whenever the court is ready for me to proceed, I do have, I believe, several stipulations.
All right, very good. Go ahead.
Thank you. My understanding is that counsel is willing to stipulate for purposes of preliminary examination, and specifically this would pertain itself to counts 2 and 3 in that same file, 25FB-1002. That defendant does have a conviction for controlled substance possession of cocaine, heroin, or another narcotic, less than 25 grams. That actually has a conviction date of January 19th, 2017, and it comes from Wayne County.
2017.
Yes, Your Honor.
Is that a correct statement?
Yes, Your Honor.
All right.
And Your Honor, is further my understanding that counsel is willing to stipulate to the admission of the autopsy reports in this matter. I have marked them as people's proposed exhibits 1 and 2. Number 1 is the autopsy report for Jennifer Burnhard, and number 2 is the autopsy report for Stevie Smith.
Is that a correct statement?
Yes, sir, Your Honor.
All right. So without further ado, I'll just do this. Those being marked, I will admit by stipulating the exhibits 1 and 2.
Thank you, Your Honor. May I approach?
Yes, you may.
Thank you. I believe that's all that I have preliminary place on the record.
Anything preliminarily for defense?
No, Your Honor.
All right, very good. You can call your first witness.
Thank you, Judge. Call Jeffrey Bernhardt. Raise your right hand.
State and spell your name out.
Jeffrey Allen Bernhard, KEYALAN, B as in boy, ERNHARD.
All right, you may inquire.
Thank you, Your Honor. Mr. Bernhardt, good afternoon. Do you remember January 1st? Do you remember how you spent that day?
Yes.
Where did you spend that day?
At our home.
What is that address?
2053 Albert Bend Road, Whitmore Lake, Michigan, 48189.
That here in Washtenaw County.
Correct.
Who did you spend that day with?
So at home was my wife, my daughter, my foster daughter, and my father-in-law lives with us.
So let's run through their names if we could.
My wife's name is Jennifer Burnhard. Daughter's name is Elizabeth. Foster daughter is Cheryl Vincent.
On that date, how old were Olivia and True?
Olivia was 9 at the time, True was 4.
What did you guys do that day?
So that was New Year's Day. We were basically taking a quiet day at home. We had family over the night before on New Year's Eve. Like 15 or 20 people in our home, had dinner, spent the time with family. So it was a lot of work preparing for that day and up to that. So we just decided to have a quiet day at home, cleaning up after the night before, and didn't do much that was significant outside of just being at home.
You recognize, sir, that you are here to talk about a very significant incident that happened that day, correct?
Correct.
Excuse me, one counsel.
Yes.
So could you move them? You may proceed.
Thank you, Judge. What time of day did that incident take place?
As I recall, it was early evening. Pretty sure it was after dinner. We had leftovers, but it was before the girls started their bedtime routine.
So sometime after dinner, but before bedtime.
Yes.
Okay. And being that time of year, I would imagine it was dark outside.
Yes.
What did you do after dinner?
So, after dinner, when I recall, the girls were just playing. We cleaned up after dinner. And I went upstairs to do something. I don't remember exactly what. It wasn't anything that was significant enough to remember.
And did something catch your attention?
Yes.
Tell us about that.
So I was in our bedroom, and our bedroom is over the garage. And in our bedroom that's attached to the bathroom that's attached to our bedroom, there's a window that overlooks the driveway. I had heard the noise outside, so I went into the bathroom, looked out the window, and I saw a car outside in our driveway that I didn't recognize.
Can you describe the car at all? Do you recall it at all?
I didn't really get a good look looking down from above. Didn't get a really good look at it.
Do you remember what the sound was that caught your attention?
No, it was, it was obviously the car. Whether it was a car door or something like that, but I did hear something in the driveway.
So you look down, you see this car that you don't recognize. What did you do next?
So I left the bathroom, walked down the hall and walked down the stairs. And my wife was right at the bottom of the stairs near our front entrance. And I told her, I said, there's somebody in our house. And we live on a private road in cul-de-sac, so it's not too often we get cars. However, her response to me was that it's likely an Amazon delivery because we still have a few things we had ordered for Christmas that hadn't arrived yet, even though it was past Christmas. So it just made sense that it was an Amazon delivery. And typically in the evenings, it was, from what we noticed, the Amazon trucks deliver during the day, and then they typically have private individuals deliver. So if there was a car or a private vehicle, it made sense that it was an Amazon delivery.
So what did you do at that point?
So, so that just made sense to me. So I told my wife, I said, okay, I'll go get it. And I walked through our kitchen towards the garage door. Typically, the Amazon delivery, they drop something off like right near our garage. So my intention was to go get the package and go through the garage.
And did you make it all the way to the door?
No.
Did something happen?
Yeah, so at that moment, I walked through the kitchen, and before I was even able to put my shoes on to walk outside, I heard, excuse me, I heard commotion, some noises, coming from the front door area. And then I heard, some screams.
Can you describe for us what commotion and noises you heard coming from the front door area?
So I heard some, like, what I describe as like some thuds or some banging. And then, like I said, quickly after that, I heard screams from little girls and my wife.
Can you describe those screams?
Sure. The screams from the girls didn't, we have, having two girls in the house playing, they oftentimes, are loud and screaming, so that didn't really catch me off guard. But at the same time, my wife screamed, and her scream distinctly, and I can hear it in my head right now, was a scream of horror and fear. And I immediately knew that there was something seriously wrong.
Was anybody saying any words?
So when I heard the scream, I immediately turned around and walked back into the kitchen and saw three individuals in the house with weapons, and they were, yelling, get down, the typical things that you would think that people breaking into your home with weapons would say, telling them to be quiet, trying to get control of the situation.
Can you describe those individuals that you saw?
So initially as I walked to the kitchen and they were in the living room, it was three African Americans, two male and one female.
Did you know any of them?
So with, before I even saw their faces, I knew that this was, I didn't know the two males, but I knew the female being Siobhan Vincent.
How did you know that?
So we were made aware of threats through family court as being her foster parents, that she made threats that she would come to our house and take her daughter. So that was in the back of my mind, that it was actually discussed just a few weeks prior to that in family court. So that was in our mind that there was that threat. So just when I saw three individuals breaking in their homes with guns, I knew instantly it was her.
And when you turned around and saw them, did that confirm what you had suspected?
Yes.
That individual, Siobhan Vincent, the mother of True, your foster daughter, is she here in court today?
Yes.
Can you point please to where she's sitting and tell us what she's wearing?
She's wearing, sorry, my color vision, but she's wearing a shirt with a white undershirt on it. She's sitting at the table.
Thank you.
Is she seated to your right or left at the table?
She's seated to my left.
All right, very good. Go ahead.
Thank you. Your Honor, will the record reflect that the witnesses both pointed to and identified the defendant?
Without objection, record shall so reflect.
Thank you. You said you saw these three individuals and you also saw weapons. Tell us about that.
So I saw Miss Vincent holding what looked, I'm not a weapons expert, but what looked like it was a handgun. I would describe it as something similar to a 9mm. The other two individuals looked what I would describe as longer guns. Don't know what type.
What were they doing with those guns?
So, that happened. I mean, the first interaction was them just trying to come in and control the situation. And I mean, the first thing that happened was Miss Vincent turned towards me, with her gun pointed, and told me to sit down in the corner of the kitchen, right around on the other side of a refrigerator. And so I was the first one to kind of told to sit down, and she quickly pointed the gun towards my wife and told my wife to come and sit next to me. And then, from what I could see, the other two defendants were kind of getting control of the girls. My father-in-law was in our den, which is a small room right by the front door. And at some point, they brought him out into the kitchen and had him lay down.
Lay down how?
I didn't see necessarily how they had him lay down.
Did you hear?
Yeah, I can hear them kind of giving him orders to get, to get over here and lay down.
Okay. And what about the girls? Were you aware at that point of where they were?
Yeah, they were both in the living room. And for context, our house has an open floor plan, so the kitchen, dining room, and living room are all open from one end to the other.
What happens after the defendant has ordered both you and your wife to sit down in the kitchen by the fridge at gunpoint?
Well, she stood very close to us, leaning against our stove, and kind of took control of the whole situation from there, and stayed there pretty much the whole time, and had, in a very aggressive way, had conversations with us, and yelling at us and accusing us of things, and doing several things throughout the night. She was also, it was very clear that she she wanted to be in charge, and she was in charge of the two other defendants.
Speculation, yeah. Sustained.
Can you tell us what she was saying to the other two?
She was saying things like, she told them to get my father-in-law and bring him in the kitchen. There were a few things she said that I didn't necessarily hear, but I remember her being upset with one of them doing something that she didn't like, and she kind of corrected them, or and things like that, telling them to go upstairs, things like
Do you know why she told them to go upstairs?
no.
Okay.
And she also, You know, at the end of the event, there were things like my dog was right next to me because he was a puppy and he was very afraid, and she ordered them to come and grab the dog and take him outside. She also, towards the end, brought her daughter and told them to bring her outside, and she had to come and get her coat and actually walk across us to get her coat. And she ordered the two men to do those things.
Do you remember anything else she might have ordered them to do? Okay. I think you also said she was yelling at you and your wife, maybe accusing you of things. Did I hear that right? Yes. Can you tell us the things that she was saying that you remember?
So specifically, she was focused on one particular accusation related, and she was focused on my wife, accusing her of not letting True believe in God, and you know, basically calling us evil and demonic and things like that because we wouldn't let her believe in God, and you know, just calling us evil people, that we were a part of the system, that we all took her daughter, and things of that nature.
Is that true that you didn't let True believe in God?
Absolutely. The irony of it is it's the opposite, because my father-in-law is an ordained pastor. My wife, up until she became a full-time mother, she also was an ordained minister with the Assemblies of God. We attend church every Sunday morning and every Wednesday night. We brought whole girls to church. They were involved in kids' church and Sunday school. Every night, part of our bedtime routine is we would sit down and read the Bible and read one or two books with each girl before we went to bed. And then even for True, even tucking her into bed at night, she slept on a loft bed, and I would, either my wife or I would stand there and we would sing Christian songs to her to help her go to sleep.
How were you and your wife responding to this assault, to being yelled at and gun pointed at you and accused of things?
Judge, hearsay is what the wife said.
Judge, any of it would be an excited utterance, present sense impression. He's there just asking for how they responded.
Overruled.
Thank you.
Mayor, go ahead.
So, it was very, very interesting. I sat there and I remember looking, I was right in front of the garage door, and I remember focusing on the hinge of the door, and I thought to myself, and I was praying, and I thought to myself, why am I not afraid? And I was kind of surprised at the fact that I wasn't obviously I was afraid, but I wasn't terrified and afraid like you would think. And I attribute that to my faith in God, and that He was helping both of us, all of us that night. But I tried to stay relatively calm, and I noticed my wife, some of the responses that she was saying. We were trying to, in a calm way, try to de-escalate, the situation and try to answer the accusations and explain some of the things that she was saying to us, that she was obviously misunderstanding something or believed something that wasn't true. And I was trying to cooperate with some of her demands related to the money and just trying to calm the situation down and hoping that she would just leave. And my wife, my wife is probably one of the most non-confrontational people that I've ever known. She doesn't like conflict, even if it's something simple. But she too tried to remain calm and answer in a way that she was trying to calm Ms. Vincent down and respond, cooperatively as to not aggravate or provoke in a calm manner.
Did any of that work?
It seemed to agitate even more. Anytime we would say anything, try to explain, it made Ms. Vincent even more upset and more aggressive.
Did she at any point talk to you about some kind of a plan?
Yeah, so at the beginning of the conversation, she was making these assertions about, in a very aggressive way, how she would use words like, I'm a gangster and I've planned this all out. And she stated things like, I don't care if I spend the rest of my life in jail. I still have the ability to harm you, even behind bars. Made statements like that, and it was very clear that she wanted that she was in charge and that she wanted us.
Speculation. I'm gonna overrule that one. I think he's been enough foundation as to what his conclusion may be. Go ahead.
Yeah, so it was clear to me that she wanted us to believe that she had power over us and that that she was not just some person who just did this on a whim, that she had been planning it and that everything that she was doing was orchestrated in a way, and in a way that seemed like she was trying to intimidate us further and make us afraid.
I believe I heard you testify a moment ago that at some point she also brought up money. Did I hear that right?
Right.
Tell us about that.
So at one point after getting through the conversation, we call it a conversation, but getting through a lot of the accusations and all that, she turned and said, "Where do you keep the money?" And my response was that where I was sitting was, as I mentioned, was right in front of the garage, the door out to the garage, and on the wall I keep my keys and my wallet right by the door. And so I told her, I said, well, my wallet's right there. I think I have a couple $100 in it. So please, take that. I mentioned, we just had Christmas, so probably the most expensive gift we got for the girls or for my daughter was a Nintendo Switch, which was like $300 or $400. So I mentioned that. I was like, there's a Nintendo Switch, you can take that. And she wasn't interested in that. And I think even one of the other defendants kind of laughed it off, like that was, they didn't want anything to do with that. That wasn't real money. So she said, where's where's the other money? And I mean, we don't have a safe with thousands of dollars in it in our house, so I said it's in the bank. And you know, somehow the conversation turned to how can we get that money? And I said something. I said I have a Venmo app, but I believe that the limit for transfer is like $500, something like that. And I said something along the lines that, you know, even if I were to go down to the bank to try to get out a large sum of money, it would, from my understanding, it would be a process. It wouldn't just be them handing me a lot of money. It's a large amount, so I was trying to say, I don't know what you want me to do per se. And so at that point, she took my wallet and the credit cards, and she already had my phone. She took all of our phones when she had us sit down. And so she stood there with the gun in one hand, my phone in the other hand, and she demanded me to give her my bank password. So she stood there for however long it took, and I found out later she transferred a total of $6,000 out of my account in two transfers, one for $5,000.
Through the use of a particular app?
Yeah, it was through Zelle, I guess, which I didn't know that Zelle didn't have a higher amount to transfer.
At some point, did you get your wallet or did she get your wallet?
Yeah, she took my wallet and took the credit cards out of my wallet.
If you said that already and I missed it, I apologize. So you watched her take your wallet from the shelf and take the credit cards out. Your Honor, may I approach the witness?
You may.
Thank you. I am showing you two pictures. They are marked as people's proposed exhibits 3 and 4. Are they pictures of things that you recognize?
Yes.
What are they pictures of?
They are pictures of credit cards that belong to me and my bank.
Are those the credit cards that you just referenced that were taken by the defendant from your wallet that day?
Yes.
Okay. And those are fair and accurate representations of what those cards look like?
Yes.
Thank you. May I approach again, Your Honor?
You may.
Thank you. Mr. Bernhardt, I'm now showing you what's been marked as people's proposed exhibit 5. That's also a picture, correct?
Correct.
What is that a picture of?
Picture of some jewelry and watch.
Do you recognize that jewelry and watch?
Yes. The jewelry, the earrings are pictures of earrings that my wife had and wore. The watch is the watch that was mine, that was upstairs in our bedroom.
Were you aware of those? Start that. Is that picture a fair and accurate representation of those items that you just described to us?
Yes.
Okay. Were you aware of any items being taken from the upstairs of your home that day, that night?
At that point, I was not aware.
Okay. Did you give permission for anybody to take any of those things?
No.
Did anybody else in your presence give permission for those items to be taken? What happens after the defendant has taken your credit cards, has your phone, and makes $6,000 worth of a financial transfer.
So, so there was a couple of things that happened during that. One of which, going back to the response that I made as far as how we responded during that time, there was something that I said trying to answer a question or trying to de-escalate, where I must have said something that was wrong or that made someone upset, but the first violent act was I was hit the forehead right on my eyebrow with what I believe was the butt of a weapon.
Who did that to you?
I believe it was Ms. Vincent.
And I'm sorry, when in that process did that take place? At some point when you were sort of.
That was first kind of early on. The one thing about this whole night is I kept thinking to myself, why are they still here? The amount of time that they spent in our home seemed like a very long time for somebody just coming in, to take their daughter. And I kept thinking, why are they here? So this felt like a very long time. But that first initial act of violence was the first thing that happened. So that was probably during the time when she was making the accusations, and I was trying to answer and explain why she may have felt or thought that we were keeping her daughter from believing in God, which was completely not true. And I was trying to explain that. And at that point, I was struck in the face. It broke my glasses, and it hurt really, really bad. Then some time passed, and it was after, I believe it was after the conversation about the money. Again, I must have said something that was a trigger or made her upset. But I was shot in the chest, and on the left side of the chest. And because I was seated, I think, I'm not a forensics expert or anything, but I think because of the angle where I was seated, probably helped save my life. And so I was shot, the angle kind of went in my chest, and bounced off a few ribs, 3 ribs were broken, my spleen was damaged. And I remember feeling, it actually, I remember feeling the bullet inside, I don't know anything about bullets, but I know bullets when they hit, they're made to kind of fracture and kind of do more damage. I could feel that literally, where it felt like fireworks were going off on the inside of me. And I still have bullet fragments in my back that I could feel. So that was the first shot. And amazingly enough, I didn't, I was still able to sit there. It hurt, like you would not imagine, but I still sat there and I still tried to calm things down and be engaged at that point. And then it was, I think they had already taken True outside and the dog, And so True came, had to get her coat and came us, walked across us. She actually wanted to give us, my wife and I, a hug.
Did she get to do that?
No. And the other thing is, the other thing that made Miss Vincent very upset was True referred to us as mommy and daddy. And so that made her more upset when she said that, and she wanted to give us a hug, but they quickly, she ordered one of the men to basically take her and get her outside. And that's what they did, got her coat and brought her outside.
Was that before or after you were shot?
That was before.
One of those men was ordered by the defendant to take True and the dog outside?
Yeah, at two different times. I mean, the dog was the first thing, because like I mentioned earlier, the dog was scared. He was a puppy, he was only a few months old. So he was literally next to my right leg as I was sitting there. And I was trying to console the dog, because I was thinking if the dog made any noise or growled or seemed vicious at all or barked, that they would just shoot the dog in front of the girls. And those girls, they love the dog. So I was trying to keep that from happening. So I had my right hand on the dog, trying to console the dog and pet him. And quickly she got nervous about that, the fact, if I would possibly do something with the dog. So, she said, "What are you doing with the dog?" And I tried to explain. And then she said she didn't like that. So then she ordered one of the men to come and get the dog. And I asked, I said, "Can I have the dog?" And there was our laundry room was right next to where I was sitting. So I was like, "Can I just put the dog in the laundry room and close the door?" And she said, "No." So they took the dog and brought the dog outside.
Who shot him?
Who shot him?
Who shot you?
Oh, who shot me? Miss Vincent.
You've told us that True was taken outside before that, and the dog. What about Libby?
So Libby, my daughter, was initially in the living room. And Miss Vincent ordered her short, the time frame, not sure exactly how long, but it was not too long after we were sitting down. So I think, from what Libby told me initially, she was hiding, or she was crouched down by the end of the couch. So Miss Vincent ordered her into the kitchen and told her to stand on the other side of her. And so at that point, when she came, she had clear view, probably standing about 7 feet from us, my wife and I, just on the other side of Miss Vincent, and told Libby to stand there and not to move. And she stayed there the rest of the night.
So Libby was standing there when you got hit in the head with the butt of a gun?
Yes.
Libby was standing there when you got shot the first time?
Yes.
How close was the defendant to you when she shot you the first time?
So she was probably about, so I was sitting next, I was sitting, my wife was sitting just to my left, about a foot from me. And then Miss Vincent was probably a foot or two from her. So, I mean, that's, I'd say 3 to 4 feet from me.
Did she say anything to you before or when she was shooting?
No, the only thing I remember about being shot in the head was she didn't say anything to me, but the last thing I remember right before that happened was my wife, in the calm, but you could tell that there was fear in her voice. She said, "Please, Siobhan, don't do anything you regret." And that just triggered Siobhan. And she got very angry. She said something along the lines, "I'll show you what I'll regret." And then from what I remember, right after that is when I was shot in the head.
Is that the last thing you heard your wife say?
Yes.
What happened after you got shot in the head?
So I was shot in the right side of my head, right in the forehead. There's a plate right in my forehead. And as I said, probably the angle, I believe that, and I've said this publicly, I believe that God was with me that day. But the angle, it went through my forehead, through my right eye, down to the top of the inside of my mouth. And I just recently, actually, about a month and a half ago, had 2 surgeries to remove bullet fragments from under my tongue because they were causing so much pain and I couldn't barely eat. So the angle of the gun or the bullet, I think that was part of the reason my life was spared. I remember being aware of the fact that I was shot in the head. I remember the sensation of blood, and I describe it like a river of hot, like fluid flowing from my head. And I fell forward, and I remember the last thing, I was aware of being shot in the head, and I, the first thing I thought was, when you're shot in the head, you die. So I was in my mind thinking that I'm about to die. And I laid down, and the thing I said, "God, help me." And what I was asking for was, "God, help me go through whatever transition, death, whatever that looks like." I wasn't afraid of dying because I believe in God and that I can go to be with Him, but I didn't know what that transition was like. So I prayed that prayer, and then I passed out. And then at some point, I believe it, somewhere around 15 minutes, somehow I gained consciousness again. And I remember the first thing that I thought was, I didn't have that sensation of that blood flowing from my head. So I thought maybe I'm not going to die. And so I sat up and I found some strength we have a bench right where the shoes are. And so I found some strength to sit up on the bench. And I knew that they had taken our phones. I didn't know if they were still in the house or not. But the first thing I thought was, I have to get to the neighbor's house and get help. So I sat there and I was putting my shoes on, and the thing, probably one of the hardest things is, as I sat there as I was putting my shoes on, I looked over and saw my wife. And I knew the moment I saw her, she was dead. She was sitting there. She wasn't even laying down. She was sitting there, and her head was hanging down, and I just literally saw blood flowing from her chin.
That's an image that will stay with me the rest of my life. But I put my shoes on and I opened the garage door and I hesitated and I said, Lord, please don't let them be in the driveway. And I opened, I hit the button to open the garage door and walked out the garage. They were already gone. And I walked over to my neighbor's house. And my first neighbor wasn't home. And so I ended up having to walk down the street to our other neighbor's house. And fortunately, they were home and they were amazing. They brought me in, sat me down, and called 911. And an officer from Northfield Township Police Department was the first one to show up. And he was amazing. All the officers from both Northfield and the sheriff, the county sheriff's office have been amazing through this. But you know, he took some information about. He was asking my neighbor some questions as well. Obviously, I was sitting there bleeding and hurt, but I was still conscious. I was still able to answer questions. And I remember after him asking my name, like who was in the house and things like that. I remember him saying, he said, okay, and he put his arm on my shoulder to come kind of comfort me. And he said, okay, I'm not going to ask you any more questions. And we were still waiting for the ambulance to show up. And I remember saying, that's okay. If there's anything you need, I remember what happened. And he said, do you remember who did this to you? And I said, yes. And I gave him Miss Vincent's name and even spelled it for him. And then the ambulance came and took me to the hospital.
Did you see anyone else in the house before you left? No, just your wife as you described.
Yeah.
Okay. So Livy was not there anymore as far as you could see.
No.
Did the defendant have permission to be in your home that night?
No.
Did the defendant have permission and authority to take True from your home?
No.
Did the defendant have permission and authority to take your daughter, Olivia, from your home?
No.
And for clarification, the dog was not there either.
No.
Dog's name?
Snickers.
Mr. Bernhard, thank you very much. I don't have any further questions. Obviously, Ms. Vincent's attorney has the right to ask questions as well. Your Honor, nothing further at this time. However, I do move to admit people's proposed 3, 4, and 5.
Any objection of voir dire?
No, Your Honor.
Exhibits 3, 4, and 5 are admitted.
May I approach, Your Honor?
Yes.
Thank you.
Sir, did you need a break for a moment or you?
No, I'm okay.
You're okay? Okay, if you need a break, that's not a problem. You're good to go? Okay.
I have cans of sparkling water. Could I offer that?
That sounds kind of fancy.
It's a little fancy.
We just drink water around
All I
here.
have.
We're kind of the out county. We don't have sparkling stuff. They do that on the other side of 23.
That helps.
That's just my thought, but yes, if he wanted some, that's fine.
Wonderful.
Cross-examination.
Mr. Bernhard, the neighbor's house that you went to, that was Mr. Ali Wright?
Right.
When you got there, Mr. Ali Wright asked who shot you, correct?
He asked me.
Yep.
I do not recall that.
Okay. You don't recall him asking. So do you recall not being able to identify to Mr. Wright who shot you when he asked?
I did not remember that conversation. No.
This is Mr. Ali Wright that I believe works, has a security company, correct?
No. Ali Wright is actually works for the public defender's office.
Okay.
He's a public defender.
I believe he works at the public defender's office. Secondly, you weren't at the front door when these individuals came in, correct? So you don't know who opened the door, correct? And you don't know if these individuals forced their way in the home or not, correct?
From the sound that I heard, even before the screams, it was very clear to me that somebody was entering forcefully into the home.
From the sound that you heard, it was very clear to you that somebody was entering the home forcefully. Do you remember being interviewed by the police and telling the police that you were unsure if they forced entry to the home or if the door was left open?
Well, I took that.
So that's not my question. My question to you is, do you remember telling the police that or not?
I did.
Okay, so you don't remember if Mr. Ali Wright asked you who shot you in the house. And you don't remember telling the police you're unsure if the individuals forced their way into the home or not. Is that correct? Saw some photographs of some jewelry that was, I presume, to be upstairs in a bedroom. Ms. Vincent never went upstairs, correct?
Correct. That I'll say this. I did not know. I did not see her go upstairs. However, I was unconscious, so I don't know where she went, where she didn't go in the house after that.
Okay, that's fair. Now, you were made aware of some complaints that Ms. Vincent had regarding her daughter, correct?
Correct.
You testified that one of the complaints was her daughter not being allowed to believe in God. Where you also told Ms. Vincent was making complaints about her daughter being physically and sexually abused at your house.
I did not become aware of the details of those complaints until after this event.
Okay, but you were aware of those complaints when the prosecutor asked you about the threats that were made and what you were told from the family court, correct?
You repeat that?
When the prosecutor asked you about the complaints and threats that were made in family court, and you told her about Ms. Vincent's complaint about True not being allowed to believe in God, you remember that? You were aware of the accusation of physical and sexual abuse then, right? When you just testified here for the government.
So I was not aware of any details of any sort of accusations of abuse that we were, towards us, towards her daughter. If my testimony is this,
Well, sir, we'll figure out what your testimony is. My question to you is, just less than an hour ago, when you were asked about the complaints made regarding the care of True Vincent, did you or did you not know that Siobhan had made complaints about physical or sexual abuse?
no, not in depth, no. Sexual abuse, absolutely not, I didn't know that was a complaint.
Okay. You didn't know or you didn't know in depth?
I did not, the sexual, I did not know at all until after all of this happened, when CPS did their investigation.
But you knew when you walked in here today to testify.
So we can be clear, the question was, how did he know it was Miss Vincent? Not what he knew. So I don't want to get that conflated. Because you're asking what, excuse me a second, sir. You're asking what he knew when he answered the question. The court's understanding of the question was not what he knew in its entirety, but what he knew that he could identify the person as being Miss Vincent. So go ahead, Cal.
Your testimony is on January 1st, you were aware that there was some complaints about True being allowed to believe in God or not.
The two main complaints that I was aware of, and the only two things that Miss Vincent discussed with us that night, was us being referred to as mommy and daddy. That was talked about in family court and addressed by Judge Miller. And more recently, which was her last visit, virtual visit with True, was when she misunderstood that and made a complaint about us not believing in God. Now, the night of the shooting, Miss Vincent never mentioned anything about sexual abuse or physical abuse.
No, stop. That's twice. I warned counsel. Counsel warned you. She can step off. You can take her. Because I'm not having it.
Judge, can we approach?
Yes, she may. Counsel approach.
I would agree.
What we're going to do is court is going to stand in recess for about 15, and we can get counsel back there to talk to his client.
All right.
Cedric Simpson presiding.
You may be seated. And if we can have Miss Vincent come out, and at the same time, we can have him back on the stand. We can, yep. We call the case of the people versus Vincent. Counsel, take your answer. Take your
I'm
answer.
so sorry. Katie Rismerski.
Good afternoon, May I please Honorable Court, Kareem Johnson, on behalf of Ms. Vincent.
Ms. Vincent, prior to what was a recess, I already had admonished counsel and told counsel that I was not going to deal with your outburst. I am not, ma'am, please don't. And I'm not going to tolerate it anymore. I let the first one slide, the second one, then that's when we took that break. I want you to be well aware and have my warning that if we have any more outbursts from you at all, that what will happen is you will then be precluded from this proceeding. We will put you in another location and you will watch these proceedings on video. You understand that?
I understand that.
Thank you. All right. Sir, I would just remind you that you are still under oath. Mr. Johnson, you may proceed.
Okay, sir, I believe before we broke, so it's your testimony that you first learned of the physical and sexual abuse allegations during a CPS investigation that occurred after the January 1st incident. Okay. Were you present during any of the video visitations that Miss Vincent had with her daughter True? And these visits, I believe, would occur once a week?
Usually.
Right. So Ms. Vincent did have contact and the ability to view her daughter. You were not able to tell law enforcement what vehicle, if any, Ms. Vincent left in, correct? You weren't able to tell law enforcement or give them a description or license plate number of the vehicle, correct? Do you remember when you went to Ali Wright's home after the incident and being asked a second time who it was that shot you? No further questions, John.
Thank you. Any redirect?
If I may briefly.
You, go ahead.
The visits that the defendant was granted with her daughter True, as of January 1st, those visits were just to take place virtually.
So, to clarify the date, I mean, I can walk you through how the visits, changed, but I just want to clarify, I want to answer your question correctly, so.
Yeah.
As of, so the visits were virtual at that point.
Yes, and thank you for making me be very clear with my language. They had been virtual for a period of time leading up to January 1st.
Right.
Were they also supervised?
Yes.
By whom?
By a caseworker from Samaritan House.
Was that your job or your wife's job to supervise those visits?
No.
Your presence in those visits or your wife's presence in those visits, what was that about?
That was just simply to, so the visits were virtual, obviously, in our home. Initially, when they first started, we were just using a laptop. As you can imagine, having any 4-year-old in front of a laptop, needed some sort of assistance because she would, push the buttons, and there were a few times where she turned the computer off. So we actually tried to help and assist with the visits to make them successful. And so we connected the laptop to a television, so True could sit at a table with toys and snacks and have this virtual visit on the TV. Now, that TV, privacy, my father upstairs in the bedroom. And, as any responsible parent does, to leave a 4-year-old by themselves in a room for an hour. So whether my wife or I, we would be in that room to assist, to make sure that the computer was turned off or there was something, going on that True was safe. When I did it, I would step into our bathroom, so she didn't have any sight because I didn't want to interrupt. My wife, when she did it, would sit off camera in a corner, trying not to distract her. And the caseworker was, as you mentioned, supervising, but was on the Zoom call.
But always there for those visits.
Yeah, so that's the way it started. When it moved from in-person supervised visits to virtual, it became problematic with those visits for various reasons, and there was a decision that was made. I don't know all that went into that decision from the foster care agency, but they made a decision that the caseworker would actually come to our house and have the visit virtually with True in her room. And so we were no longer, once those started, we were not, for the most part, a part of those visits, except when the caseworker couldn't come.
How long had that been the case before January 1st?
I believe it was so the last visit happened towards the end of November, and I think that that was the case probably for a month and a half, possibly 2 months. The visits were not always consistent.
I was going to ask that. Why not?
Because of Ms. Vincent would cancel or not show up or show up late, and we get rescheduled. So it was a problem. We had several discussions with the foster care agency about how to improve and make that better for all of us. Yeah.
I think just one last issue. And it has to do with those 3 individuals entering your home that evening. You've talked about noises and you've described them. Was there any property damage? Tell us about that.
So there was, the way I describe it is, we had to fix all the property. There was several quotes from contractors, and then our insurance company had did an evaluation and paid out, and the total amount that was paid out from our insurance for everything was $50,000. A portion of that was from just the cleanup. And there was significant damage to our floor, obviously from the gunshots and the blood. There were sections of our floor that were removed because of that. There was damage to parts of our cabinetry that had to be done. There was damage to going up the stairs, the railing. There was several things that had to be repaired in that. There was damage to the front door, the main door and the screen door. The screen door was replaced. There was had to replace the hinges on the door, and there was sprays of paint that I haven't even done that yet, but that needs to be repaired. And yeah, that was pretty, I mean, there's a list from the insurance company of all the details, but that's what I can recover. So the damage to fix everything, which didn't even cover the floor, but it was paid out of about $15,000 from the insurance company, but that didn't even cover the floor.
Specifically as it pertains to damage to those doors, the screen door and the front door, were those items, those doors damaged in any way before that incident that night? Thank you. I don't have anything from.
Anything else?
No.
All right. Sir, you may step down. Thank you very much for your testimony.
And Your Honor, for clarity, may he be released from his subpoena? I believe he desires to leave.
All right. Any objection? All right, yes, you're released. Sir, take care. We call your next witness.
Good afternoon, Your Honor. Jacob Candy for the people. At this time, the people would call Sergeant J. Basso.
Sir, please come forward and be sworn.
Officer, testimony. Say and spell your name.
James Basso, Jamesso.
All right, you may inquire.
Good afternoon, Sergeant Basso. How are you doing today? Where is it that you're currently employed? And how long have you been employed there?
I've been employed with Northfield Township for 5 years now.
Do you have prior police experience to before joining the Northfield Township team?
31 years of experience.
And in your capacity as a sergeant with Northfield Township Police Department, were you working on January 1st of 2025?
I was.
And were you dispatched to Noller Bend Drive?
I was.
That's in Northfield Township in Washtenaw County?
Correct.
Do you recall what time the dispatch came in?
Roughly 8:30.
Roughly 8:30. And do you recall what the nature of the dispatch was?
The caller stated there was his neighbor was on his porch and he had been shot in the face and in the chest.
And where did you respond from?
I was in the Eagle Garden subdivision, which is off East Shore Drive near Posey Drive.
And did you go straight to the address dispatched?
Yeah, it was a wintry day. The roads were kind of fairly snow covered, so it took me a little bit to get there just because of the condition.
Sure. And what address were you initially dispatched to, if you recall?
I don't recall the exact address.
Would a 2039 Noller Bend?
Sounds correct.
And what happened when you arrived there?
Officer Diacono was treating, later identified as Jeff Burnhard. He was talking to Jeff and giving treatment, medical care to him. There was some concern of other potential victims at the house, Jeff's house.
Okay.
So myself, a couple of Ann Arbor officers and some deputies went to the neighbor's house and left officers Diacono and Musser to treat the patient.
Okay. Before we move on, did you observe any injuries on Jeffrey Bernhard when you made contact with him that night?
Yes.
Could you describe those injuries to the court?
Yeah, I went into the breezeway, he was sitting in a chair. The right side of his face had massive damage. Eye was completely swollen up, very bloody. We had removed his t-shirt and then there was a gunshot wound to his chest.
And at that point, are you relaying any information to dispatch or relaying any information to?
We're sharing as much information as we're getting between myself and the other officers that were initially on scene. We were sharing information over dispatch. It's the quickest and the most efficient way to do it.
Okay. And you said, and then you traveled to another home. Is that correct?
Yes.
Do you recall the address of that home?
House directly to the east of that residence that we were at.
Sure.
I do not recall the specific numbers. No.
Okay. What, a 2053 Noller Bend?
Yes, that would be one.
And when you arrived at the home, was the front door of the home open or closed?
So the front door was closed. The garage door, the main garage door was open. The lights on were in the garage was on, as well as lights on within the house itself.
Did you observe any damage to the front door of the home?
No, we did not.
Could you describe to the court your entry into the home?
So, once we had sufficient manpower and we waited for an Ann Arbor officer to get there with a ballistic shield where we had stacked up and made entry into the home. I had set up enough people to guard the exit to the garage to make sure as we went in one door, nobody was going out the other door. So we had some planning to put strategic people around the house to make sure as we went in. Once we got enough people, the front door was open, it was unlocked, closed but unlocked, and we entered in like a stack type formation behind the sheet.
And did you discover anything in the entrance of the home?
As you walk in the home, there's a hallway. There was a room initially to our left, which ended up being like a den or an office area. That hallway opened up into a bigger area with the living room on the left and kitchen on the right. As that hallway came in, we could see two legs kind of poking out on the floor into the hallway. As soon as we made entry, we saw it and we're like, we got somebody down, we see the legs. And that's when we continued down that hallway.
And at that time, did you know if there was anybody else in the home at all?
The only information we had was what we were relayed to us by Jeff, which was his wife was there and his father.
So what happens next?
We secured the one room on the left. We went into the kitchen area and we started to secure, making sure there was nobody in the living room. We went into the kitchen. Right immediately to our right, there was two sets of stairs, one that goes up and one that goes down. The Ann Arbor officers stood point there while I continued into the kitchen. And when I walked through the kitchen, there was another body down the hallway that goes to the garage, just like right around the kitchen corner.
What did you do next?
I cleared that hallway. And then there was a pantry area to the left. I cleared that. And then I took point by the stairs while the Ann Arbor officers went up and down and cleared the second story in the basement.
And at that point, did you check on the victims or were you still in the process of clearing the home?
We had made sure everything was clear and there was nobody initially was there. I checked both patients for any signs of life and there was.
You know, at this time, I'd like to approach with people's proposed exhibits 6 and 7.
Yes, you may.
Approach. Thank you, Your Honor.
Start off with
People's proposed exhibit number 6. Sergeant Basso, could you please tell the court what that image is?
So that is the image of Mr. Smith on the floor. That is the position that we found him in. His legs, these are the legs that were protruding down the hallway. The hallway was been running like that.
And were you able to determine where the gunshot was or?
And once I checked him, I did not roll him over or move him in any way, shape, or form at that point.
Okay.
So I had no idea where he was shot at.
And he's in that photograph in a lying down position.
Face down on his belly with a large pool of blood coming from underneath his head, chest area.
Okay, perfect. I'd like to move on to the next exhibit, exhibit number 7. Could you tell the court what that photograph is?
That is the picture of Miss Burnhard, the way she was as I entered the house.
And in that instance, were you able to determine where the gunshot was?
I did not move her. I'm assuming it was her head just based off where the blood was coming from and her body positioning.
Your Honor, at this time, I would move for the admission of people's proposed exhibits number 6 and 7.
Any objection or voir dire?
No, Your Honor.
All right, exhibit 6 and 7 are admitted.
Did you then relay any information to dispatch at that point?
Yep, as we made in, every time we came across a body, we informed dispatch that we had a person down and we had a second person down. We also informed them that we were clearing the house with the initial search. We actually did two. We did the initial one for adults. We did a secondary one to look for any kids that were hidden because we knew that there were two kids in the home. We didn't know if maybe they were hiding in the home. That was still at an unknown at that point in time.
Did you locate any children in the home at all?
We did our secondary search, which was a little more detailed, looking into cabinets, looking into doors, looking into more smaller areas within the house where kids might be hiding.
And was that information relayed?
Yes.
And following the first and the secondary search, did you then secure the home?
Yes, at that point, once we knew nothing was in the home, I secured the front door. I posted up one of the other Northfield officers at that door. And then I closed the garage door to maintain the security from that entrance. I wanted one way in, one way out for anybody going into the home.
And did you remain at the home throughout the night or did you go somewhere else?
For the majority, but I was also once Detective Roberts showed up and Lieutenant Powell, we had enough. They were doing the processing of the house. I went to try to notify next of kin. I then eventually went to the hospital and interviewed one of the subjects that got arrested.
And just one additional question. Throughout either your primary or secondary search of 2053 Noller Bend that night, did you notice any bullet casings?
So once I made an entry into the kitchen, Mr. Smith was on the floor. As soon as you turn right into the kitchen, there's like an island with some chairs. Along with the stairwell, there were two that I can remember, brass bullet casings, pistols. Pistol casings.
No more questions from you, Your Honor. Thank you.
Cross-examination.
No questions.
All right, thank you. Thank you. Can you make step down? Yes. Thank you. May call your next witness.
Thank you, Your Honor. Ellie Zend on behalf of the people. Your Honor, the people would call Deputy Judge. Please state.
Please come forward and be sworn.
I swear or affirm the testimony you're about to give me, the truth, no truth, and nothing but the truth, so help me. Will you have to see, state, and spell your name?
Gabriel Bechtel, Gabriel
You may inquire.
Thank you, Your Honor. Deputy Bechtel, where are you currently employed? And how long have you been employed there? And do you have any prior police experience? Okay. And were you working in your capacity as a deputy with the Sheriff's Department on January 1st of 2025?
Yes.
And what was your assignment on that date? And what does that mean?
Just drive around the township, enforce traffic, and take calls and service.
Okay. And how long does that shift normally last for?
12 hours.
So would that be, when does it end? What time on this specific?
Start at 8 p.m. I end at 8 a.m.
So this would have ended on January 2nd at 8 a.m.?
Yes.
Okay. And on that date, were you in a patrol vehicle by yourself?
Yes.
And was it a marked patrol vehicle?
Yes.
Okay. And on that date, did you assist Northfield Township Police Department with an investigation? What was the context of that investigation?
Metro East Dispatch advised that there was a shooting that just occurred shortly after shift change, so shortly after 8 p.m. And then one of our deputies, there was a name release, a possible name release, and one of our deputies saw that there was contacts with a house in our area in Ypsilanti Township. And I went to that house and sat nearby.
And do you recall where that house was, what the address was? And is that in Ypsilanti Township?
Yes.
Washtenaw County, state of Michigan? So you went to sit at that location. What happened while you were at that location?
I was sitting just next to just west of the address at a park, where I could see the front of the house. And I was just waiting for any suspicious activity or vehicles to come and go. And then a black SUV pulled out of the driveway and turned and went eastbound on Lexington Parkway.
So pulled out of that 1201 Lexington address.
Yes.
Okay. What did you do after you saw this vehicle?
I then turned on my headlights and caught up behind the vehicle and to try to obtain a license plate. Right when I got behind the vehicle, it turned off into a driveway.
And
it turns out all over the road and right into a driveway, and I drove past it.
okay. And then what happened?
I sat down on the road a ways and a couple houses down and watched for more suspicious activity. And then the vehicle backed out, went back northbound on Fall River, and then westbound on Lexington Parkway. So I called back up to the vehicle again, and it repeated its previous behavior and turned into another driveway. So I went past it, sat a couple houses down, and then again reversed out, went back westbound Lexington Parkway, past 1201 Lexington Parkway again, then turned southbound on Glenville Ave. I caught up to the vehicle. It turned onto Rambling, I believe, and then it turned again onto Raleigh Court, which was a dead end. And then I went past it again and just sat down by the baseball court where I could see the entrance of Raleigh Court on Glenville Ave.
Okay. And did the vehicle leave that street?
No, the vehicle never came back.
Okay. And at that time, did you observe anyone in the area?
And a black male came running out around the court, crossed the road, and then started coming toward my patrol vehicle.
And what did you do at that point when you saw him coming towards your vehicle?
I then drove towards him and I initiated my overhead lights and got out of the patrol vehicle speed.
And what happened next?
I asked why he was driving the car around with no license plate. And I asked why he dumped the car down on Raleigh Court. He told me that he was.
Objection, hearsay, but this is what you're saying.
And we'll move on from what he said, Your Honor.
All right, very good.
So without getting into what the individual said, what did you do next after speaking with that individual?
Once I figured out that he was coming from 1201 Lexington, I detained him.
Okay. And then what happened?
I placed him in my patrol vehicle. And then I saw a black female walking from Raleigh Court towards my location.
And who did that female turn out to be?
Siobhan Vincent.
And how did you know it was Siobhan Vincent?
She was identified by her Michigan SOS photo and date of birth.
Okay. Siobhan Vincent in the courtroom today? Can you identify something she's wearing and where she's sitting in the courtroom?
She's wearing a gray jumpsuit.
Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Without objection, record show so.
So did Siobhan say anything to you when you first encountered her?
When I first encountered her, I was on foot and she said that she was looking for her son.
Okay. And what did you do next?
And then questioned her where she was coming from. And she also stated 1201 Lexington. And I asked for her name and she told me that her name was Ty.
And then what happened?
Then I went to detain her and she became uncooperative. I reached for her wrist, she pulled away from me. And at that time I had more units coming to the area because I explained that I was dealing with people that were possibly related to the street. And then one of my Deputy Hannah, while she was resisting and helping place her in handcuffs.
Okay. And after she was placed in handcuffs, what happened next?
Then I conducted a pat down with Deputy Hannah on her left side. I just patted down for weapons.
Did you locate anything? Okay. And after the pat down, or during the pat down, did she follow instructions? What was she doing?
She started bending over and right to the shoulder pain and wouldn't stand up straight.
So what did you do after that?
After the pat down was done, I tried to place her in the back of patrol vehicle 72, and she was uncooperative and wanted to get inside the car.
So she was refusing to get in the vehicle? Okay. And after, did you get her in the vehicle eventually?
I did not.
Was she placed in the vehicle eventually by someone?
Yes.
Okay. And after she was put in the vehicle, what did you do next?
Like she said, there was more deputies in the area at this time. Because I said that there was a car that was down Raleigh Court, but they were unable to locate that vehicle. So then I walked over to Raleigh Court where the other deputies were to try to assist them with finding the car. That was what I believe she left the abandoned Raleigh Court.
Did you find the car? What kind of car was it?
It was a compact Beamer.
Okay. And where was that vehicle at when you found it?
All in the first point of Raleigh.
Okay. And what did you next after locating the vehicle?
Deputy proactive, he approached the vehicle on foot. Where we then found 2 males inside of the car and a juvenile female with 3 dogs.
Okay. And did you ever identify who that child was? Who was it? Okay. And was Olivia removed from the vehicle? And were the 2 gentlemen removed from the vehicle? Okay. And to your knowledge, was Olivia supposed to be in that vehicle? And did you observe anything else in the vehicle?
While walking around the back of the vehicle after everybody was out of it, I saw a shotgun in the rear hatch underneath some like furniture or clothing, and I could see the stock.
Okay. So after clearing that vehicle, what did you do next?
I then went back to the original scene where it Vincent.
Okay. And when you got back to the original scene, what did you do next?
At that point, she was then identified, and we knew that she was under arrest. And we asked for a female officer to come conduct a full search.
Okay. And was Siobhan cooperative with the search, to your knowledge? How was she not cooperative?
Once the female officer arrived on the scene, Officer Barici, we asked Vincent to step out of the car, and she refused to step out. And she was given multiple orders to step out of the car. And she eventually said, if the male deputies step away, then she'll come. So we stepped back, and she finally stepped out of the car for a search.
Okay. And during that search, was she cooperative? Cooperative. To your knowledge?
Yes.
Okay. And was there anything located on Siobhan during the search?
Yes.
What was that?
Officer Barici located what she believed was a gun underneath Vincent's left armpit. She could feel like the metal, and she called out, saying that she thought she found a gun and for our assistance. So then we went hands on with her, and I grabbed onto her left arm. Deputy Hannah grabbed onto her right arm. And then Deputy Burton was able to pull the handgun out under her armpit.
So you saw the gun come off of Siobhan Vincent's person? Okay. And at the time that handgun was located on her person, approximately how long has she been in contact with police?
Approximately 30 minutes.
Okay. And when that gun was located, was it loaded?
Yeah.
Can I have one moment, Your Honor?
You may.
Thank you. Nothing further from people for this witness, Your Honor.
Cross-examination. Deputy, when you first went to the location, it's at Raleigh Court? Is that the name of the street?
Yes.
Did you have a warrant for the arrest of Siobhan Vincent? Yep.
You mean Lexington Parkway?
Lexington Parkway?
When I first went there?
Yep.
Okay.
Did you have a description of the individuals that were allegedly involved in this incident at the time you first went there?
Briefly.
What do you mean briefly?
I remember that there was 2 males involved with U of M Michigan sweatshirts.
Okay. Did you have the height of any suspects involved?
No.
Hairstyle of any of the suspects involved?
No.
Okay. When you first observed this woman walking down the street, what was she doing wrong? Okay, so you get out and you then seize this woman who you see walking down the street that's not doing anything wrong, correct?
I have no question.
Well, when you got out, you cut on your overhead lights, correct?
Before she. Yes.
Right, so you have your overhead lights on, but you're in the car, right? Correct?
When the mail came from.
Right.
I was in the car, yeah.
So you get out of the car, you've detained the mail. The mail is now in your car. Is that correct?
Yes.
You're back in your car.
No, I never got back.
Okay, so you're outside your car. This woman is walking down the street, and while you have your overhead lights on, you then walk towards this woman.
Yes.
Okay, and then you start to question her. Correct?
Yes.
At that point, she's seized. Correct? Right, because if she'd have turned and ran, you would have chased her. Correct?
Yes.
Okay. Now, you have this woman seized that you haven't seen do anything wrong. You start to question her. Did you Mirandize her before you started questioning her?
No.
Before you searched the car or that you went with other deputies to find, did you have a warrant to search that car?
I didn't search.
Okay, you didn't search the car. Okay. And to be clear, when you went to handcuff this woman that you saw walking down the street, you hadn't observed her commit any arrestable offense.
I wasn't questioning her about it.
That's not my question. When you went to handcuff the woman that you saw walking down the street, who turned out to be Miss Vincent, you hadn't witnessed her commit any arrestable offense, correct? No further question.
Any redirect?
Nothing for the people, Your Honor, for this witness.
All right, just so that I'm clear, Deputy, at the time of the search of Miss Vincent's person by the officer that was called to the scene, that was an Eastern Michigan University police officer?
Yes.
All right. She's not cooperative in terms of her search initially. And you were there. Was there a detective Hannah and a detective or a deputy? Hannah and Burton also present at the scene while she was doing that?
Yes.
Okay, so there were basically 4 officers there while she was being uncooperative regarding the search purpose.
Yes.
All right. Any questions based upon the court questions?
Oh, Your Honor.
All right.
No,
Thank
Your
you.
Honor.
Thank you. Thank you, Deputy. You may step down. They call your next witness.
Thank you. Call Detective Sergeant Roberts.
Please come forward and be sworn.
Oh, your hands, please, so your name.
Jason Roberts.
All right, you may inquire.
Thank you. Sergeant, where do you work?
Northfield Thompson Police Department.
What's your position there?
Detective Sergeant.
How long have you been with Northfield Township?
I'm a 27th year
How long have you been a sergeant?
since 2018.
Same period of time being a detective as well?
I was an detective from 2012 to 2017 roughly. And then got promoted back to the road and then went from the road to detective sergeant position.
Sergeant, you've been here in court throughout the proceedings for this afternoon, correct?
Yes.
You are who we commonly refer to as the officer in charge of this case. Is that fair to say?
Yes.
Okay. What is the first thing that you did as a part of your investigation?
When I got to the scene, the first thing I started running a search warrant, I believe, for the Lexington address.
For Noller Bend or for the Lexington?
I'm sorry, well, for both. I did do Noller Bend probably first, and then I did the Lexington address. I did search warrant for both.
Okay. Did you at any point go to the Noller Bend home?
Yes.
Did you go inside?
I went inside after MSP was done processing private just.
Okay. Explain to the court what that means about MSP coming to process for evidence.
Because of the type of crime scene it was, we didn't have the personnel or the experienced personnel to process that type of scene, the larger scene. So we requested MSP's crime scene unit to come and process the scene for us.
So they did that exclusively?
Yes. At the Noller Bend residence.
We've heard some testimony about some weapons that came up when deputies interacted with the defendant.
Yes.
Did you come into contact with those weapons?
Firearm, the sheriff's department. Later that evening, my security guard property.
What about the shotgun that we've heard reference to?
So on January 2nd, I executed a search warrant on that Honda HRV, also the sheriff's department in their evidence garage. And I located that shotgun in the rear hatchback area of that HRV.
What did you do with it after you found it?
Both guns were secured into evidence for processing.
May I approach, Your Honor?
You may.
Thank you. Sergeant, we'll start with people's proposed exhibits 8 and 9. Those are pictures, right? What are the pictures of?
Exhibit 8 is a picture of the shotgun as it lay in the back of the vehicle.
And 9.
9 is a different angle of the same shotgun.
Did you take those pictures?
I did.
And are they fair and accurate representations of where that shotgun was as you saw it when you were processing that car?
Yes.
And now I'll hand you people's proposed exhibit 10. What is that?
It is a picture of a 9mm handgun.
Is that also a picture that you took?
Yes, it is.
What gun are we looking at?
This is the firearm that was taken off Siobhan Vincent, turned over to me.
And is that as well a fair and accurate representation of that gun as you saw it here at the TV? Thank you. Your Honor, this time I move for the admission of proposed 8, 9, and 10.
Any objection or voir dire?
No, Your Honor.
Exhibits 8, 9, and 10 are admitted.
Mayor.
You may.
Thank you. I'm sorry, Sergeant, you said you did what with them when you're done processing that car and you've got those weapons?
They were secured in our police department, and then the next day, I believe I just dumped over to MSP's right to their firearms investigating.
What's the purpose in taking them there?
Fingerprints, DNA. I've been testing for the handgun to match any possible shell casings found at the scene.
And there were casings found at the scene, correct?
There were.
When MSP comes to process a scene, as you requested them to do here, do they author a report pertaining to that?
They do.
Does it describe the things that they did there, the things that they saw, and the things that they take into evidence?
Yes.
And as the OIC, in this case, you are in possession of all the lab reports that have been authored as a result of their work in this case, correct?
Yes.
And have you reviewed those?
I have.
Okay. Before I hand those to you, let me also ask you this. When Mr. Bernhard was here testifying, he identified some pictures of some credit cards and then also some jewelry. Do you recall that?
Yeah.
What can you tell us about those credit cards and jewelry and how they became a part of the evidence in this case?
Those specific cards and that jewelry was also turned over to me at the DV unit here at the Sheriff's Department. They were items removed from the two co-defendants in this case, Callahan and Finley.
We've heard testimony about Olivia being in the car in question with the two males. Did you hear that? We did not hear about True being in that car, correct?
Correct.
Was True found as a part of this investigation?
True was located at the Lexington address.
And we've also heard testimony that that Lexington Parkway address is somehow connected to the defendant, correct?
Correct. That is from others' residence.
From others' residence. Thank you. What about the dog?
Dog was located in the car with Olivia.
And that's Snickers that we've heard about?
Yes.
Okay. Snickers is back home as well?
Yeah.
Okay. What about checks and or checkbooks? Did those play a role in this investigation at all?
So Mr. Jeffrey's father-in-law had a checkbook ledger with his name, I believe his church's name on it, that I recovered on the floorboard of the backseat of that vehicle when I did the executive search warrant here at the Sheriff's Department on that Honda HRV.
So you're saying there was a checkbook of Stevie Smith?
Yes, sir.
Okay. All right.
Thank you, Judge. And may I approach again, Your
You
Honor?
may.
Thank you. If I'm tracking my numbers correctly, sir, I believe we're on 11 and 12, and that's what I'm handing you right now, are people's proposed exhibits 11 and 12. What are those?
They are forensic reports from the Department of State Police.
They have your name on them, correct?
They do.
Okay. Do they have your incident number for this case as well?
They both do.
Okay, so they are lab reports that were generated pertaining to work done by the lab on this investigation.
Correct.
And they are record number 1 is people's proposed 11, correct?
I'm sorry, yes, record number 1 through because of 11.
Okay, and record number 3 for proposed exhibit 12, correct?
Correct.
Okay. As we've discussed, record number, strike that. Your Honor, at this time, I move for the admission of people's proposed 11 and 12 pursuant to statute as lab reports at pre.
No objection.
11 and 12 are admitted.
Thank you. As to 11, this is the crime scene report for going and processing the scene, as we talked about, correct?
Correct.
And it references in there, among other things, casings that were found and recovered and seized as evidence as part of processing that scene, correct?
Right, they refer to them as wired cartridge case.
Thank you. I always get the gun on go on. Now moving to people's 12. Are those fired cartridge, did you say cases? Yes. Are they also referenced in record 3?
They are.
As well as the firearm that we saw in the picture, the pistol that you took to the lab that was removed from the defendant for your left armpit, correct?
Correct.
And were those items compared to one another?
They were.
And is there a conclusion or a comparison to be drawn between all of the casings at the scene and the gun that was taken off of defendant's person?
They were identified as being fired.
Yes.
Thank you.
Thank you.
Did you also come into contact with the defendant as a part of your investigation?
I met her, I think it was in the county jail.
Was she in custody of that?
She was.
Did you interact with her?
I did myself and Detective Sergeant from the state police interviewed her together.
Why did you have somebody from the state police with you to do that interview?
There was, at that time, we had so many suspects and so much scene that one person couldn't possibly do it all. So we kind of divided the time period who's doing what. I chose a female sergeant to interact with me with my suspects.
Did you or the officer that was assisting you advise the defendant of anything prior to talking to her?
The female sergeant, I believe her name was Jacobe, to look out her name. She did Mirandize Ms. Vincent prior to speaking to her.
And were they the Miranda rights that you are familiar with?
Yes.
Okay. And did the defendant appear to understand those rights?
She did. She waived the rights and said she was speaking to us.
How long did you guys talk to her?
45 minutes to an hour.
Long time.
Yes.
Without going through all of it, let me ask you just several pointed questions. We've heard some questions asked and some information put on this record about child abuse allegations and sexual assault allegations from the defendant to the Bernhards, correct?
Correct.
During that interview with her, did she say anything about any of that stuff?
The only assault she ever mentioned during our interview was that she witnessed someone push her daughter at one point during a virtual visitation.
So that's all she complained about to you.
That, and if they would not let her daughter say the word holy. Yes.
Holy.
Correct.
You didn't cut her off or keep her from talking to you about anything, did you?
No.
As we've indicated, you're the OIC of this case. Are you familiar with really basically all of the reports, the documentation, all of the investigation that's gone into this?
Yes.
Have you come across any evidence to support the allegations that the Bernhards physically or sexually abused True? Have you come across any evidence to support that those were allegations that even existed before she murdered two people in that home that night and tried to murder a third?
No, we did not discover anything prior to January 1st.
Again, condensing a long, lengthy interview down to just a little bit, but let me ask you, did anybody ask her, did you do this?
We did.
And what did she say?
She said that she shot them. She said whoever was in the house, she shot them.
Thank you. I have nothing further.
Cross-examination.
First Sergeant, you did participate in this interview, correct?
Yes.
And interviews have certain tactics, correct?
No.
Okay. And you're trained on interview tactics. Okay. Would you agree with me that the tactic you used in interviewing Ms. Vincent was to simply ask her, a broad question and allow her to just talk, get her to speak freely?
She did speak freely, yes.
Okay. But that's what you wanted her to do, correct?
It hurt, yes.
Okay. Do you know how many times during the course of that 45-minute interview, Ms. Vincent said to you, "They hurt my kids. You don't fuck with people's kids"?
I couldn't tell you how many times she did reference it. Yeah.
She referenced it more than once, correct? Would it be more than 5 times?
I don't recall any times.
Did you ever ask her, what do you mean they were hurting your children?
I don't know specifically answer that question.
Okay. You are the officer in charge of this case, correct?
Correct.
there was multiple suspects being interviewed, correct?
Correct.
You were communicating with the other detectives during the interview, trying to make sure you guys were getting similar information
I don't believe during the interview.
after the interview.
Yes.
And you looked at the reports of those interviews. Okay. There were other suspects that said Miss Vincent complained that they were abusing and molesting her children.
Okay, is there a question on that?
Yes, that's the question. That is true, correct?
I don't believe so. I have to look at those reports.
Okay. We're looking at well, first, before today's date, did you look at the report of Detectives Russo's interview of Defendant Callahan?
Not recently.
Okay, but
I'm sorry, you mean Sergeant Basso's?
Yes.
I've seen it, yes, but not recently.
Okay. In that report, was that discussed with that suspect?
I'd have to look at the report to answer that question.
All right, young man, approach the witness.
You may, if that will refresh your recollection as to whether or not it's there.
I see Callahan's statement, yes.
Did you check to see if Ms. Vincent had filed any CPS reports or made any complaints to the CPS worker of this sort of abuse being done to her daughter?
We have spoken with Samaritas and CPS, yes.
Okay. Did you get any reports from those entities, either one of those entities?
I'd say hundreds.
Okay. No further questions, yeah.
Any redirect?
No, thank you.
All right. Thank you, Detective Sergeant. You may step down.
Your Honor, people have no further presentation.
All right. Witnesses for the defense.
None, Your Honor.
All right. Are you ready to go into argument at this point? Did you need some time?
I'm ready to go.
I'm ready, Judge.
Go ahead.
Prior to argument, I wonder if I could make an official motion at this time to add count 11 to file number 25F3-0011. That is count 11 of armed robbery. That's seal 750.529. Judge, I would like, if the court is amenable, to have it read identical to the co-defendants, which is did in the course of committing a larceny of money and or jewelry and or credit cards and or checks and or checkbook and or a dog, use force or violence against a person present and or assault or put in fear a person present, Jeffrey Burnhard, and in the course of that conduct possessed a gun, a dangerous weapon, contrary to statute.
All right. Very good. Any response to that at this point? Your adding of that count. I don't think she needs a formal motion, actually.
Right. If the court wants me to address, I guess it'd be more efficient if I did everything at once.
Yeah, that's fine. That's fine. I just wanted to give you the opportunity if you wanted to. I do need a pack code on what you're requesting being added.
750.529.
Thank you.
Thank you, Judge. And then one other minimal amendment, if I could, that is on file number 25FB-1002. Count one is carrying a dangerous weapon with unlawful intent. And currently it reads, did with the intent to use the same unlawfully against a person of another, go armed with a firearm, to wit a shotgun. I would like that to read to wit a handgun.
Gotcha.
Thank you.
Okay.
Judge, following those amendments, I would simply indicate to the court that by a burden of probable cause at a minimum, that there is sufficient evidence on the record here before Your Honor that all of those crimes as charged have been committed, and further, there's probable cause that your defendant committed those crimes. Judge, I get the argument about home invasion. I'm not going to belabor the court, the AWIM and the homicides, as if the eyewitness firsthand victim account isn't enough. Your Honor has Peoples 11 and 12 in front of Your Honor that indicates that the gun that was found in the defendant's armpit is the gun that fired all of the shots in that home that night, matches the casings. So you've sewn up all of the shooting committed by the defendant herself. She took the kids. You heard the testimony. She had no permission and authority to take the kids. I think if there's a quibble in the charges on that case, it is the home invasion. Whether or not somebody allowed her access to that home that night, be it one of the children or Jennifer, as they were the ones that were standing by the door. But Judge, any argument about them being there with permission just fails, and fails utterly, in light of what Mr. Bernhard heard and was so eloquently able to articulate, which is he heard thuds and bangs, then immediately he heard screams and screams of fear from his wife that he will literally never forget. Add to that some damage to the door, and I think circumstantially you have more than enough to find that they entered without permission, and then the rest of the count flows from there and is satisfied by Mr. Bernhard's testimony. Judge, we simply ask that you bind the defendant over on all of the charges as originally indicated in the charging documents, and then also with the several amendments that I requested. Thank you.
Yes. Response. Just briefly, as the home invasion, I think the record is clear. The witness presented by the people was not in the room when entry was made into the home. The court is asking, the government is asking the court to take what this witness's speculation as to what noises mean and accept that witness's interpretation, what those noises mean, as to whether or not they got into the house with permission or not. We don't know, and the witness could not testify. Did those thuds and all that banging around, did that happen after they were allowed into the home and they were taking people or asserting their control over people or not? So based on this record, I ask the court to not bind over on home invasion first degree. Also, and I'm not, with count 8, conspiracy to commit home invasion, I'd ask that it be dismissed as well for the same argument. And first, there's a difference in aiding and abetting and conspiracy. And the conspiracy, requires that government prove, and at this stage, prove up upon the evidence that they unlawfully conspired, combined, or confederate or agreed together to commit these offenses. And there's no testimony on this record as to a conspiracy, even if the court believes that there's testimony record to support an aiding and abetting theory. There's no testimony record to support conspiracy. As to counts 5 and 6, kidnapping and child enticement, at this point, I'm gonna be honest, with the court, We want to object, just for the record. There's some issues that I think are present in that, in terms of did the government prove that they took the children with intent to detain or conceal, the child from, its lawful parents or guardians? If the record, and the record is clear that there was at least a belief by Ms. Vincent that the child was in danger. And so we'd ask the court to not bind those over. And I think whether or not the belief or the court believe that the belief is reasonable or not, that may go to the murder counts. But as for the child enticement, and based on the fact that at least True was taken to the grandmother's house, based on the testimony, the True was not in the car. We don't know what the intent was of my client in terms of who she was trying to keep True away from, if anybody. And I think the argument would go the same as to Olivia. Now, as to
okay, I just want to make sure I'm clear. You're saying that with reference to basically counts 5 and 6.
Yep, it's not just that I take the child. I'm sorry, Your Honor.
No, go ahead. No, I'm gonna say
it's not just that I take the child. I have to take the child with the intent of hiding the child from its lawful parents or guardians, and not even addressing the fact that clearly at this point it's the government's position that the parents, or the foster parents at least, are dead, right? So what do but still, even if the court finds that the killing, based on the record, was to facilitate the child enticement, if the court made that reach, whether or not you hide something from a dead person, I guess that's something we're going to have to argue about. But still, the intent in terms of taking the children, especially based on the fact that the evidence shows that at least True was taken to another location, I guess we don't know. I don't think that the government has proven what the intent was when Ms. Vincent allegedly took her child.
So True. I guess my question is, and I understand your argument, may not agree with your argument, but I understand your argument. You're saying that argument would also apply to Olivia?
Well, at this point, Your Honor, there's no testimony as to who took Olivia out of that house. There's no testimony as to whether or not Ms. Vincent ordered that Olivia be taken out of that house. And there's no testimony as to what anybody's going to do with Olivia. So I just think that the record is, we're all operating under the assumption that Olivia was taken by Ms. Vincent, and we're operating under the assumption that Ms. Vincent ordered that. But there's no testimony to that on the record.
Okay.
And as to the other cases, the R&Os, Your Honor, I'd ask that those counts be dismissed, Your Honor. And the issue becomes, was there, at the moment that there was police interaction with Ms. Vincent, was there probable cause to arrest? And based on the answers from the officer, I believe that answer at that moment was no. So at the time in which she is fighting or resisting or not obeying those commands, do not believe that there was probable cause to arrest her. And when you are trying to put somebody in handcuffs, that level of seizure is an arrest. And even if the police develop that probable cause at some later date and time, or some later time that day, they didn't have it at that moment, Your Honor, then we'd ask court, we don't believe they had it at that moment, we ask court to dismiss those charges.
Your additional response from the people?
I'm almost not even sure how to respond to the kidnapping argument, because what you have in front of you is 3 individuals armed with weapons coming into a home without permission, unannounced, and without lawful authority, killing 2 people there, trying to kill a third, and taking the kids with them. that do not belong to them. If that's not kidnapping, I don't know what kidnapping is. Judge, as it pertains to the RNOs, they're certainly nowhere near the most important charges on the charging documents. That doesn't mean that it didn't happen. There's a concert of action that happens when investigations like this unfold. Deputy Bechtel knew exactly where to go, and that's because he had information from other law enforcement officers about an address that was right close by that was connected to the defendant. So he sat up there and he watched this car do all of this evasive maneuvering, and then an individual gets out that his suspicion is now already raised about her involvement for multiple reasons, to include that she's there at that address in the first place, and matches whatever minimal description he has about shooting, about a super violent double homicide, could have almost been a triple homicide. He has every right and every responsibility to approach her and to protect the public and detain her until he figures out what's going on. And she resisted, pulled away, didn't respond and comply with orders on down the line in every way that she could resist. Are they the most important charges? No, they're not. But have they been satisfied by a standard of probable cause? Absolutely. And again, as for the kidnapping, Judge, I'm not sure how kidnapping gets more clear. You don't get to snatch people's kids, whether the people you're taking them from are alive or dead. Thank you.
All right, court's I want to take a look at a little bit more closely some of the defendant's arguments, particularly regarding the home invasion and the kidnap. So court's going to take about a 10-minute recess. I'll come back and give you my decision.
All right.
Given the stipulation that there is the predicate counts that would make Ms. Vincent a prohibited person, and also given the testimony, the court would find that the people have sustained their burden and would bind the defendant over, in that case, on all three counts, dismissing count 4 as the people are not proceeding on that count. With reference to case 25 FB 1003, given the testimony in the case of the firearm being found on the defendant in her armpit, as well as the testimony of